issued long back. Honorable Court has also, my lord, passed 2 orders, one detailed judgment. In spite of that, my lord, so my lord, it may be listed for hearing. Last occasion, it was listed on 26 April 24.
Rule issued already.
Yes, my lord.
Then let it be
Earlier,
listed.
last occasion, my lord, the order is that, my lord, the writ petition is admitted for hearing, list the matter after 2 weeks for hearing on a date fixed by the registry.
Then
But
let it be listed for orders, we'll fix it up.
yes, my lord. Next week or my lord, hearing date, it may be fixed, my lord.
Have to be listed on 10th of June.
10th of June
Yes. For orders.
for order.
Yeah, please.
Obligatory.
With the consent of the other side, I beg to mention item number 15 of the daily list. Dr. The senior arguing counsel is not present today due to some personal difficulty or occupies a adjournment in the matter.
Item 15 at the request of Mr.
And the
Anand Datta. Counsel for the petitioner, matter stands adjourned to be taken up.
on can it be on the and this Friday, your Lordship.
Friday.
Yes, Lordship.
All right. Friday.
Friday of blind.
Passed over. Right.
May it please my lord. I beg to mention item 37 and 38, my lord. I seek adjournment for the day, my lord. My lord, we have to file a reply in the case, my lord. We'll file, my lord, and the conducting counsel is stuck in waterlogging.
37, 38.
RCC interest.
Who's for the respondent?
My lord,
Have you taken consent?
my lord, the conducting counsel is stuck in floods, my lord.
No. Have you taken consent of the other side?
No, my lord.
Please do. Please
Okay.
take consent and
Okay.
come back.
Obliged.
May it please your Lordship. Lordship, with the consent of the other side, I beg to mention item number 34. Lordship, we are yet to, within a week, we will file our affidavit in opposition, and it may come up after a week.
Yes, any objection? Item 34, you're for the respondent.
Lordship,
Item 34, at the request of learned counsel appearing for the respondent, matter stands adjourned for 2 weeks. Prayer made is not opposed by the counsel. Please stop.
obliged.
Please, the Lordship. Lordship, I'd like to request a WPC for listing.
What is the subject matter?
Lordship, the petitioners have a bank account with a respondent bank, but they are being restricted from withdrawing any amount of money from it.
Which bank?
State Bank of India.
You filed your petition.
Yes, Lord.
When?
Lordship, the petition was filed in April of 2024. The last date of posting was on 8th May. It was fixed for service report after 2 weeks, but it has not come up since. It's about to be a month.
List on 14. 14 June.
Lordship, item number 7 and 8, Lordship. Kindly take up the matter after end of all the motions, Lordship. I have some personal leave right now, Lordship, that's why. Deeply obliged.
Delegate for motion item 1.
None appear.
Item 2.
Please, the Lordship. Lordship, this is a contempt petition for the non-compliance of the order dated 11/9/2023, my lord. The order is at page number 14, my lord. And the operating party is in page number 15 and 16, my lord. Para 4 and 5. Para 4, my lord. And the page 13 is the communication, my lord.
Agreed by the willful and deliberate non-compliance of the order dated 11/9/2023. Right. The direction of the court, the contempt petition is for it to be respondent number 3, the writ petition for release of the remaining amount of 11 lakhs. Not later than a period of 4 months from the date of the receipt of the money. It's submitted that the certified besides being an inter-party order, certified copy of this order was served on. When did you serve the
29/2023, my lord. 29/2023.
Where is that?
Page 13, my lord.
Page 13.
13, my lord.
Serve the copy the DC by Representative
Acknowledgement.
2009. He submits that its order has yet not been complied with according to the content. Like it is returned for 4 weeks. Steps are responded by legal courts and registered courts within a period of 1 week from today. List after return.
Lordship, my senior D. Borua's name has not been reflected in the process.
The D board one.
Item 3,
Yes, Mr. Roy.
Thank you, Lord. My lord, I had order dated 30th of March. I was directed to file an additional affidavit, filing in for delay in filing the writ. Accordingly,
Have you
lordship,
received the copy?
I-
Anything you want to submit?
no, lordship, the rule may be issued at this stage only, or notice.
We'll issue notice that heard.
Fine.
For the part. 4 weeks. And then 4 months. Date pretty thorough, good taking by order dated by your order dated 13/3/2024. This court express its view that they become unlegally by the therefore permitted we can file affidavit explaining the state affidavit by additional affidavit by bringing submitting that
कुछ नहीं लिखा, किस तरह से टाइप किया, कौन किया? कौन किया?
state and board of appeal court.
I'm appearing for
Chaji for
1 and 2.
3, 4, 5,
Fine. 1 for 3, 4, and 5.
5.
Since the council that renders representative with important notices of which have a record copy furnished within this period of 1 week. You serve copies within 1 week.
Today will. Obliged.
In fact, my lord, that's Title 5, my lord, subdivisional committee, land advisory committee that has to be represented by as the deputy commissioner.
Whatever. You get
Like
your
the,
instructions in respect of the concern from the concerned officer.
item 4,
My lord, hearing that we are innocent of the inaction of the deputy commissioner in pursuance to it, my lord, complaint filed by this petitioner organization. My lord, the fact hearing is that the petitioner's organizations were my lord, supplying tracks, my lord, for loading of unloading of goods in the Harmony Junction, my lord, in the process cargo and deep freight chain. Thereafter, my lord, there's some respondent number 7 to 10 has my lord forcefully taken away the my lord, that work of my lord, supplying of track in collaboration with respondent number 7, my lord. And my lord, they are my lord operating some kinds of my lord syndicate there. They are taking my lord 10,000 rupees from each track and on 2 rupees from my lord, considering this my lord, the quantity of items loads in the tracks 2 to 5 per bag while loading. And my lord, so regarding explaining all this aspect, my lord, we have the submission. The petitioner organization has submitted a representation that lordship will file at page 37.
Why have you not filed FIR?
FIS, my lord, we have filed a deputy commissioner is the my lord, competent authority to my lord, look after this all. And my lord, we have filed FIR, FIR we have filed, my lord, and my lord, and we have filed my lord, communicated with the all concerned
Where is
authority.
your FIR?
FIR, that is my lord, will find page 34. FIR file, my lord, and we have that the petitioner organization has communicated with every single authority of railway, police, railways, SDCs and all, my lord. Thereafter, they are not taking any action. Only my limited prayer is that, my lord, that representation is pending.
No, maybe pending. Why should we issue a direction?
But
You
all in
can-
inquiry done as
You
part of
find out
findings.
whether any FIR has been
Yes,
registered.
my lord, that will
Find
be
out.
appropriate. If any fire is registered, then
The
it's-
police
it
also
will
not
take
taking
its-
any action.
You find out whether FIR has been registered, whether
well,
it
it
received,
will take
what
its
is the
own
status.
course, my.
Heard learned counsel for the parties, the grievance of the petitioner is that the private respondents have restrained the petitioner from functioning for supply of trucks to the Harmuti Junction for carriage of goods from the railway freight train. Because of these harassment faced, several representations have been filed by the petitioner organization before the Commissioner's authority, including the SP of Kimpur district and the DC of Kimpur district. Is submitted that no action has been taken by the respondent in spite of the representative by learned government advocate MSM Orban will obtain status of whether any FIR has been registered pursuant to the complaint filed before the SP of Kimpur.
Annexure 6, date is 2/11/2023.
To the SP as well as to the in charge of the police outpost, which are in the information. It is instruction for the court on
2 weeks, my.
2 weeks. On 19th.
Hmm.
In order to facilitate the government advocate to obtain instruction, the extra copies be furnished within a period of 1 week.
All right.
Item 5,
May I please, Your Lordship? Lordship, this matter pertaining to aspiracy, Your Lordship. Dear Lordship, on last occasion, Honorable Court direct to file an additional affidavit regarding the others claim. And accordingly, Lordship, on 21st of last month, we have filed an additional affidavit. And we have stated there is a MSCD petition was pending before the learned member number 1 of Kamruk Metro, Your Lordship. And that case was fixed for argument on 2/8/2024.
Is there a bar for getting claim?
No, Lord.
No, apparently that 1511 notification doesn't say so.
Yeah.
So you examine,
Yes, notice may be issued, my lord.
we dispose it off. For what purpose? The DCV is required to conduct the examination,
Lordship.
Yes,
inquiry. Any found to be correct?
all the
Some
relevant
proposal.
documents may have to be produced, my lord, including NOK and all listed,
Yes.
my account
And
details.
produce it before the commissioner and secretary,
No, God.
revenue disaster.
Yes.
Yes.
So he will appear before he will submit everything before the deputy
Deputy
commissioner.
committee. On
Once the deputy
verification, my
commissioner,
lord,
once he verifies, then he sends the
That's what
proposal
we're
to the
saying.
for
commissioner.
sanction, my.
For sanction.
The two, how does that know? Okay, heard learned counsel, the parties, petitioner is before the court agreed that petition is not being granted ex gratia in terms of the notification dated 15/11/2014 for an accident which occurred in a public place, leading the death of the petitioner's
Son,
son.
namely Biraj Dev.
The accident occurred on 26/11/2017. And in terms of the notification, the petitioner is entitled to receive an ex gratia payment plan. This court had earlier directed the petitioner to apprise, to state before the court by filing an additional affidavit as to whether any claim petition has been filed before the Motor Accident Claims Tribunal. The additional affidavit has been filed on 28 May 2024, wherein there is a clear averment that claim petition has been filed before the MSCP Kamruk Metro and is registered as case number 347, 2018. And the matter is now fixed for argument on 8/2024. Parapeated as it may, for perusal of the notification enclosed to the writ petition. There is no condition that claims made under MSCT with the bar claims to be made under the same application, or claims to be made and payments to be released under the same application. So, the matter will require verification at the by the concerned DC. So accordingly, this court of the view that the matter can be closed at the state with the direction to the Deputy Commissioner, Morrigaon District, to examine the claim, the petition regarding her claim for release of compensation under so and so notification. So the DC will call for all relevant papers from the petitioner as well as from other departments and authorities as may be found to be necessary. And upon upon due verification, if the DC comes to a conclusion that the petitioner is entitled to be granted a claim, a proposal in terms of the notification dated so and so. The proposal is the proposal mentioned here, right?
Yes.
No, it's not mentioned.
No,
The proposal for grant of the benefits of court be prepared and forwarded to the office of the Commissioner and Secretary, Department of Revenue and Relief and Disaster Management, Revenue Relief, Rehabilitation and Disaster Management. Stop. If such a proposal is forwarded by the concerned DC, then the respondent number one, namely the Commissioner and Secretary, Revenue Department, will thereon pass necessary speaking order. And if the petitioner is found to be eligible, the amount of compensation payable to the petitioner in terms of notification will be released. So the DC will examine the matter within a period of 30 days.
2 months, my lord, because it has to be
from the date of
verified.
receipt of a certified copy of this order. And if such a proposal is forwarded by the DC upon due verification, the office of the Commissioner and Secretary, then the Commissioner and Secretary will examine the proposal and pass a speaking order deciding the claims of the petitioner under the so and so notification or grant of ex gratia benefit within a further period of 60 days from the date of receipt of the proposal of the DC. The petition accordingly stands closed.
We may submit the along with copy of the writ petition along with the
Why
certified
is the
copy.
writ petition next step?
All the documents are annexed here, my lord. It will be easier for him.
The petitioner will
Make
file
to fill and
a copy of the writ
detail.
petition along with the certified
Yes, ma'am.
copy
Will help him.
of this order before the DC.
DC.
deeply.
May I please, Lordship? Lordship, here is a petitioner on the strength of the valid sale deed applied for mutation. Now, while this mutation application was made, the private respondent opposed the same mutations, and thereafter hearing took place, and finally order was passed in my favor. Thereafter, the respondent again challenged this thing before in a way of appeal before the Deputy Commissioner. That appeal also upheld the order of the cycle officer. Again, it was challenged before the Revenue Board by the respondent. Now, while taking into consideration of these all facts, the Revenue Board came at a conclusion that we have a valid sale deed and also position like in our favor. But only one score, this order was interfered with, saying that because there is instructions, government instruction which demands that because the particular land required, if transferred, then there must be necessity for prior government approval. Now, Lordship, thing is that this is totally a new fact which has been inserted in the order. At no point of time any hearing took place, number one. And number two, my lord, it was also not the ground of challenge of that appellant before that, my lord, revenue board. Lordship straightway, I would like to draw out the attention of this honorable court, the impugn order, two or three paragraphs. My lord, page 54. Paragraph 4, may I read, my lord? Page 54. Paragraph 4. Respondent number 1 acquired the property through sale deed 2008 dated 14/3/2008, purchasing it from Naresh Chandra Ghosh. Naresh Chandra Ghosh in turn has obtained the property from Sonapur Tea Company through sale deed dated 3646/1966 dated 10/5/1966. Both of these sale deed remains legally valid as they have not been annulled in any court of law, and this validity persists to the present date. Following the execution of the sale deed, it is understood that the respondent initiated the mutation case in Sonapur Revenue Circle. On 15/9/2008, the circle officer passed the mutation order in case number so in favor of Srimati Dipti Mehdi, holding the opinion that respondent has possession and title of the land. The land records are silent on the land possessed by the C. Purna Sekhi or late Kanto as referred in the unregistered deed. The IDC Kamrup in revenue appeal number appealed the circle officer's decision, noting that the appellant failed to provide valid land document during the proceeding. According to Section 53 of the Assam Land and Regulation Act 1886, the process of mutation necessitated two conditions: number one, title, and number two, position. In the present case, the appellant stated that respondent number 1 lacks physical position of the mentioned land despite acquiring it through Naresh Chandra Ghosh is a power of attorney. However, the order from the circle officer Sonapur Revenue Circle in mutation case number 167.
What is the position now?
It is in my position. There is a house, man.
No, there is a direction that the circle officer will revisit the mutation if
But
required.
on what ground, Lordship?
Whatever it may be, has the circle officer initiated?
Yes, sir. Yes, sir. There is a direction in this order that
Has the circle officer taken up the proceedings again?
No, till that, my lord, we have not received any notice. Lordship, my SL is on paragraph 9, my lord.
We'll examine it.
But Lordship, only one score is very important. Now the respondent is trying to, my lord, they get their mutations. My lord, if that, my lord, it will, my lord, create a third party interest.
No, that mutation will be subject to issuance of notice. to
My,
you.
understood. But my lord, if suppose that proceeds been prima facie, my lord, this order,
That proceedings will hear you before that proceeding.
absolutely, my lord. Lordship, what I'm saying, my lord, at this moment, Lordship, kindly see that tenability of this order. My lord, all score is very important. Lordship, just kindly see the emphasis which has been given on the basis of page 57, my lord, instruction, executive instruction. That has been relied upon. Now, Lordship, on this score, Lordship, only I want to rely one paragraph of the judgment, my lord. It's an executive instruction, my lord. It's not a statute, my lord. Just look for a moment at judgment of this honorable court.
No, but this executive instruction is issued by whom?
But this executive instruction issued by perhaps revenue authority, my lord, because my lord, there is no indication. We have just got this copy, my lord. But question is that, my lord, on the kindly see, my lord, the issue is that the land was already converted in 1966.
We are examining it. We are not throwing away. a
My
petition.
prayer is, my lord, to stay this, my lord.
So
order.
that's what we are asking you. There is a direction for a fresh verification, so and so. But this, let us see what instructions come here.
My lord, instruction, but lordship, that one observation is necessary otherwise.
Who's for the respondent? Have you?
Yes, my lord.
You have to serve copies on the respondent before a stay is granted.
My
Are they
lord,
on caveat? No caveat.
no caveat, sir. 3 to 7 are the private respondents.
Perhaps, my lord, as he is assailing the Board of Revenue order, my lord.
Yes.
That may be made a party, I think, my lord. He has not made Board of
Why
Revenue.
Board of Revenue? Why is it necessary to
Not
be a part?
necessary, that is.
All
Third
relevant
speaker
documents
is
for.
Tamariel and counsel to the and MS
I'm for only
Forum
two, my lord.
appearing for respondent number
1
2,
and 2.
Mr.
Revenue
Bhattacharya,
and
PR Monto appears for respondent number 1. Oh, you're not for Director of Land Records.
They are under revenue.
Petitioner is assailed the order of the Assam Board of Revenue.
Revenue.
Dated 26/12/2023. Passed in case number 10 RA K 2020, whereby the mutation which was granted in favor by the circle officer of which district?
My lord, Sonapur, my lord, Kamrup Metro.
Kamrup Metro,
Metro.
which was held by the DC. Kamrup Metro has been reversed, and the circle officer, Sonapur Revenue Circle, has been directed for a fresh re-verification of the operation of the city land. The circle officer was directed to revisit the mutation in terms of the existing government instructions. You were not heard.
No, my lord, on this issue, the appeal that has been heard, my lord, but so far this issue is concerned, that has been abruptly, my lord, added in this order.
Learned counsel for the petitioner submits that the question of whether the executive instructions will have a binding effect on the order passed by the mutation order passed by the circle officer was never a issue before the circle officer or before the DC. And in the present appeal, this question was decided abruptly without
Given any opportunity of hearing.
giving any opportunity to the respondents, to the appellants, to the respondents, namely the writ petitioner hearing, address this issue. So he therefore submit his order requires appearance, and the order passed by the circle officer, Sonapur circle officer, circle officer, Sonapur Revenue Circle, and upheld by the DC, Kamrup Metro, should be restored. So, he submits that this office memorandum, this instruction was issued when?
But this instruction issued, my lord, dated 4/8/1995. There,
Issued on
Okay.
4/8/1995. Whereas the land has come into the possession of the writ petitioner from
sorry, my lord, date is 26/3/2021. Sorry, my lord. 26/3/2021. 2001, my lord. Paragraph 9.
notification dated 26/3/2001.
One.
And your possession is
I am position from my lord prior to that, my lord, 66 sale deed was executed by that my predecessor.
whereas the petitioner has come into possession of the said land by execution of the proper sale deed in the year 1966. Para MS Tilana Government Advocate appearing for the department. Submitted that instruction. Accordingly, the notice be issued returnable 4 weeks steps on this private respondents by general courts and registered post within 1 day. Since the respondents 1 and 2 are represented by the county, so to pay power since there is a prayer for an interim order, notice of the interim prayer returnable on '24. Notice returnable on 24. Stay also returnable on 24. In the next date fixed, the operation of the new order shall remain stay.
Our name may be reflected, madam.
The names of the standing council they reflected. in the
Funded the Item 9.
Commissioners, before your lordship, it's an association consisting of the Kutch community people, my lord. They have their reserve community under the OBC, my lord. The grievance of the petitioners is that by way of a corrigendum, my lord, their identity has been clubbed together with Rajbongshi, which is a totally separate identity as per the petitioners. Now, my lord, prior to the corrigendum, in the in the OBC list at serial number 18, it used to be Kuch or Rajbongshi. So a person could have identified either as a Kuch person belonging to Kuch community or Rajbongshi. But by way of the corrigendum, the letter, the word or has been deleted and it has become Kuch Rajbongshi. So my lords, the contention is that they are the Kuch, so far as the Kuch community people are concerned, they belong to a non-Mongoloid, belong to a Mongoloid and non-Aryanized community, whereas the Rajbongshis are non-Mongoloid and totally fully Aryanized. So my lord, there is an act, my lord, which is also appended in the writ petition. The name of the act is Assam State Backward Classes Commission Act. Now, my lord would find it at page 31, the act. Page 31 of the writ petition. Now, this is a statutory body, my lord. Under this act, there's a commission. Section 3 is the constitution of the commission and its functions. My lord would find it at page 36, section 9, 9.1. The commission shall examine requests for inclusion of any class of citizens as a backward class in the list and hear complaints of over inclusion or under inclusion of any backward class in such list and tender such advice to the government as it deems appropriate. The advice of the commission shall ordinarily be binding upon the government. So, my lords, the petitioner had also approached before this commission, my lords, but they have not disposed of the representation, my lords. So, since I would pray, my lords, since there is a commission, a statutory commission, which is there to therefore redressal of the grievances. So, if there's a direction that, my lords, our representation.
Why do we direct the commission?
We have already, because there's an ever been, my lord, paragraph 5. We have approached the commission and they have not
Why should we issue a direction to a commission?
to dispose it off.
Which is to be presided over by a former judge of the High Court or the Supreme Court.
Yes, yes.
Why should we issue a direction?
In that case, my lordship may issue notice, then
We don't know. You tell us if the matter is pending before the commission.
matter is not pending, my lord. My lord would find it.
No, but you said no order
My lord
representation is
would come to
pending.
page 12 of the writ petition, my lord.
Yes.
My lord, the paragraph, I'll read the paragraph. It is humbly submitted that noting the discrepancies with regard to OBC certificate, which was being caused by the operation of the corrigendum dated so and so, the petitioner society approached the statutory authority, that is the Assam State Backward Classes Commission, and the respondent department with its grievances by its representation dated 5/11/2021. So, my lord, the commission was approached, but there is no.
Lordship, in this
And
matter,
in the meantime, I've been told, my lord, the respondent number 1, the nomenclature has changed, my lord. Earlier, it used to be the Department of, my lord, Department of Welfare and Plain Tribes and Backward Classes. Now, the nomenclature has been changed to Department of Social Justice, my lord, and Empowerment.
You change it, correct it.
I'll correct it, my lord.
Yes.
we don't have any instruction right now, but that has changed. Nomenclature has changed.
The nomenclature will change. You find out what is the status of this
Yes, Lordship.
representation. You let him get the instructions. Hard should be Mr. C. Sharma appearing for respondent number 2 and 3.
Yes, Lordship.
MSM Bormon for respondent number 1. Chief Secretary.
Aye.
The grievance of the petitioner is that by a corrigendum dated 3/8/2011, is the community, the courts. Where is the original notification?
That notification, my lord, we could not find the notification out there. Original
Submitted that in the original notification
1975.
in 1975, where courts or Rajbongshi, members of courts or Rajbongshi community were notified as members of the state OBC list. Or you write, under the state OBC list, the community of Koch or Rajbung was then listed. So by subsequent corrigendum issue in the year 2011, this was altered to within Koch Rajbung. So the grievance of the petitioner is that they had approached the appropriate forum, is the Assam Backward Classes Commission, by filing necessary representation in the year 2021, as well as the Department of Welfare of Plains, Tribal and Backward Classes. However, no steps have been taken to redress the grievance. So it is submitted that Koch and Rajbungshi are two separate communities with separate identities and culture and practice. Therefore, clubbing them together as Koch Rajbungshi has the effect of putting the members of the petitioner association may have the effect of placing the members of the petitioner association to be identified as a community which is not accepted or known in the society, namely Koch Rajbungshi. Council appearing for the department will obtain instructions with regard to the representation stated to have been filed with the Assam Backward. What is that commission?
The Assam State Backward Classes Commission.
Assam State Backward Classes. That extra copies be furnished to the respondent in a period of 1 week from today. Let the matter be listed again on 24th of June.
Lordship, the name, name is reflected as SC Water.
C. Sharma, Council for the Backward Classes Community. Sorry, Council for the what?
Social Justice and Empowerment.
Social Justice and Empowerment Department submit that the department has been renomenclatured as
It was WPTBC before, my lord. Now it is Social Justice and Empowerment.
submit that Department of Welfare of Plains, Tribals and Backward Classes has now been renomenclatured as
The Department of Social Justice and Empowerment.
Social Justice, Department of Social Justice and Empowerment.
Lordship, it will be under the administrative control of Department of Social Justice and Empowerment Department. The directorate is Directorate of Welfare of Scheduled Class and Backward Classes.
We will not make the directorate a party, my lord.
And the Directorate of Scheduled Caste and Scheduled Caste and
Scheduled Caste and Backward Classes.
Backward Classes
Lordship,
is
may
the necessary party.
look into the notification.
This directorate is the necessary party and the same is required to be added to the party. And Counsel for the petitioner is permitted to make the changes in the course title and array the appropriate directorate.
Directorate is not a necessary party.
You don't know. By filing amended course title within a period of 1 week. Let's start on 24.
GA may be shown.
WPTBC, can we change it by hand, my lord? Department of English.
No, it has to be by amended course title.
Yes.
Not by hand.
GA may be also shown, reflected. GA may be also reflected as I'm taking notice correspondent number one.
Names of all the councils be reflected in the court by the rates.
Obliged.
Item 10. Yes.
Regarding force measure, my lord.
Force majority. All right.
Lordship has
Need
passed,
to notice 12-6.
my lord.
Yes.
Then similar order, my lord.
Mr. S. Yal appeals to the respondent.
My lord, item number 10, 11, 13 and 17 are same, my lord.
10, 11,
13 and 17, my lord.
13 and 17, same.
Also 18 and 19 also same.
Huh?
18 and 19 also.
18 and 19,
Obliged.
all to be listed on 12/6. Steps on the respondent, then extra copies be furnished.
My lord.
You file your response if any.
Yes, I've already filed. I'll submit my.
The doctor also appeared,
Yes, my lord, for respondent number 1.
respondent
Yes.
1, Mr. Chaudhary for state PS. Yes.
Obliged, Your Lordship.
I think 12.
May it please the Lord.
Yeah.
Lordship, in this case, we are agreed by a demand from show cause notice as well as a subsequent order in original Lordship by the service tax department. Lordship, what has happened in this case, Lordship? Lordship, in the year 2019, Lordship, on the basis of data received from the income tax department, the service tax department issues a demand come show cause notice to the petitioner, saying that they have short paid service tax and accordingly they were asked to show cause as to why a certain amount of service tax should not be paid by them. Against the said show cause notice, Lordship, we filed a reply asking for a date of personal hearing as well as asking them to give a proper breakup of the amount. Lordship will find that reply at page 36. In fact, Lordship, eventually the department was kind enough to grant us the opportunity of personal hearing, right? Notice dated 18/2/2022, which is at page 37, Lordship. Hereby, Lordship, the opportunity of personal hearing was granted on 28/2/2022, 2/3/2022, and 4/3/2022. However, Lordship, unfortunately, this letter was received by us only after the due date of personal hearing were over. We received it on 10th of March 2022. On receipt of the same, we immediately write an email to the authorities informing them that we have received the letter today itself and another date of personal hearing may be fixed. However, Lordship, the respondent authorities goes on to assess the petitioner without giving any opportunity, and order in original Lordship was passed on 28/3/2022, which your Lordship will find at page 40. The relevant part, Lordship, is at page 44, whereby service tax demand including cesses amounting to rupees 7,66,860 with equivalent penalty was imposed on the petitioner. Now, Lordship, after the order was passed, the petitioner prefers representation before the authorities, saying that the opportunity was not given, and also, Lordship, the services, taxable services that were rendered by the petitioner during that financial year were exempted as per the mega exemption notification. So, Lordship, on getting no response from the authorities, the petitioner eventually belatedly files an appeal, Lordship, and the appeal was dismissed on the ground of delay. Now, Lordship, what has happened, Lordship? We have approached this court agreed by the order on 2 counts, Lordship. One is that we were not provided an opportunity of hearing. Secondly, Lordship, the services that were rendered, which were also under taxable services according to the respondents, in our view, Lordship, they were exempted by the mega exemption notification. Lordship, similar matters are already pending before this honorable court, whereby this honorable court, while issuing notice, has granted interim protection to the petition.
If earlier cases are on different footing, here they file appeal. When appeal was admittedly the time passed. Against that, Lordship, appeal to the CCC is maintainable. Approximately to see page 86. Paragraph 10.
There are statutory appeals.
Yes, Lordship.
Why have we not gone in appeal? Further appeal?
Lordship, in another case, Lordship, this court has entered in even after the appeal, we have approached this court and this court has issued notice. I have the order with me.
What order? Why have we not enclosed that order?
Lordship, the relevant part is that para 3.
Notice has been issued.
Notice has been issued and Lordship, it has been stayed also, the order. Lordship, notices has been issued and stay has been granted, Lordship. The issue is same, Lordship. Here also, Lordship, we have approached the court after the appeal was dismissed. In that case, appeal was dismissed on merits, Lordship. In this case, it was.
You are aware of the law laid down by the apex court and so many other judgments that when there is a the mechanism for statutory appeal, you have to exhaust that. You have to satisfy the requirement of having no efficacious remedy. Your remedy is there under the statute.
Lordship, but Lordship, there's also,
Unless you fall within those exceptions.
Lordship, there's natural justice has been also validated, Lordship, one of the grounds. But in that case, Lordship may entertain this petition.
Yes, Mr. KL.
I have preliminary question. First, Lordship, secretary appeal is the provision of.
On top of that, this order was passed when?
Lordship, which,
This impugned order in original?
Lordship, it was passed 23/2022, Lordship.
Then 22.
22, Lordship.
We are in 24.
And Lordship, appellate order was passed on 13/11/23. That is also more than 8 months ago.
Lordship, in fact, Lordship, peruses page number 88, Lordship. We were recently issued with the recovery notice, Lordship. It is dated 2/2024.
It's not a ground. On what basis you are not aware? Where were you? Maybe you were evading the notice for the order. Heard learned counsel for the petitioner parties. This petition challenges the order in original. Passed in. Where is that order?
Lordship, the order is at page 37, Lordship.
37.
37.
This is the notice for hearing.
40, Lordship. 40.
Sorry, Lordship, it's at page 40, 23/2022.
Order dated 28/03/2022 passed by the Deputy Commissioner Audit against the writ petitioner. Whereby demand of service tax, including cesses amounting to 7,66,860 has been confirmed for the financial year 2014-15 under section 73(2) of the GST Act, with a penalty of 1,000 under section 77(2) and a further penalty of 766,860 imposed on under section 78 of the Penal Act. So, learned counsel for the petitioner submits that against this appeal, against this order, an appeal was filed before the Commissioner of Appeal. Then Commissioner appealed, then the same also came to be dismissed on the ground of limitation by the order dated 13/11/2023. So, the petitioner has also put to challenge the notice for recovery of government dues issued on 2/2/2024. So, the grievance of the writ petitioner is that the services which have been said to be the services rendered by the writ petitioner, which have been found to be under the realm of service tax by the assessing authority, is actually exempted. The way is the notification.
Lordship, I have not annexed the notification, Lordship. We have extracted the relevant portion, Lordship. Para 15, Lordship. The notification date is 26/2012.
The mega exemption notification number 2512 dated 2006/2012 is submitted that under this mega exemption notification, the services rendered by the petitioner were exempted, and therefore for the period of the question, the impugned order passed by the commissioner, by the assessing officer, is contrary to the notification issued by the government of India, and therefore no recovery can be paid. Yeah. He submits that these notifications, these orders passed by the assessing authority, being contrary to the notification itself, the impugned order is going to be interfered with, satisfied and quashed. That apart, this fact not having been considered by the appellate authority, the impugned order of the appeal of required to be interfered with, and consequently, the new order of recovery of government dues is also required to be interfered with. Mr. HKL and planning on GST submit that this writ petition is not maintainable as petitioner in the further appeal. The
86 of Finance Act 1994 for the CSEC, Calcutta.
before the CSET was required to be filed by the petitioner under the provisions of 86.
86 of Finance Act
Finance Act.
1994.
However, the petitioner has not gone in further appeal, and the same is contrary to the law made out by several judges of the apex court. He therefore questions the maintainability of the writ petition itself. Issue notice returnable 4 weeks. KL complete instruction that complete is instructed by the very count to advise. Matter be posted after 4 weeks. 17th of July. Stop. Till the next returnable date, the demand for recovery, ID order dated so shall remain state. The respondents, the petitioner will take necessary steps of the respondent by serving extra copies during the course of 1 week from today. Question of maintainability left open.
I'm obliged. Item 14.
Right. My lord, the petitioner is a owner and in possession of a plot of land, my lord, measuring 7 bighas, 2 katha 8 lisa, and the land is in possession since 2005, my lord. And in 2007, my lord, the one Sojan Thousand, my lord, who was staying in the backyard area, he expired in 2007. And during that time, from 2007, my lord, till now, my lord, it is a settled position that there is no dispute or difference between the parties. And the right of the petitioner over the patta land is there where petitioner is doing cultivation, my lord, and there are valuable trees, my lord. Tandan trees, my lord, Segun tree and betel nuts. My lord, your lordship will find the patta, page 19. Some patta I have annexed, my lord. Page 19 is one of the patta for the year 2010-11, my lord. Page 19 in middle portion, your lordship will find third line. Patta is granted for the year 2010-11. Then second patta, your lordship will find that is in page 24, my lord. This is also for the year 2023, my lord. Page 24, middle portion. My lord, when everything of the petitioner is, my lord, in intact, my lord, all of a sudden, my lord, without, my lord, due notice, my lord, previously, my lord, this page 27, your lordship will find, then one notice was issued, notice in the form of letter, my lord, page 27, that is under challenge, my lord. This was, my lord, dated 28 to 24, but they did not provide the notice on that date, my lord. They sent in WhatsApp, and later on, my lord, I obtained it on 16th of March.
What is LP?
LP is Lot Patwari Inserts. May I read, my lord? This is absolutely without jurisdiction, my lord. With reference to the subject cited above, I am to inform you that as per Lot Patwari Inserts, my lord, Langting and official Jamamanti records, the land measuring 3 bighas 5 kathas is only under your possession of land situated surveyed Notun Hazar Part 1 village area under Langting Monja, and the rest of the land is under the possession of late Sojan Thousand. Now I have mentioned, my lord, that late Sojan Thousand, he expired in the year 2017. Since then, my lord, that was a settled position. I have a patta, my lord, and patta described that I have 7 bighas 2 katha 8 land. And the entire land, my lord, I have annexed the photograph, is a bounded land, my lord, where I am doing cultivation, bounded by wooden boundary.
Now after this, my lord, this notice, my lord, in the form of letter, my lord, it is issued with my lord vested interest, my lord, to give some undue right to a third party. My lord.
You go and file an appeal before the DC. Why have you not filed an appeal?
I am challenging this notice, my lord.
I know. Why not challenge it before the departmental authority? You have forums for appeal.
But that is the thing, my lord. There is the remedy, my lord. Sought for, my lord. Remedy sought for, my lord.
What is the remedy?
Remedy sought for is, my lord, here, my lord, is to set aside this notice.
Why?
Because,
not
my
go
lord,
in
there is no forum, my lord.
There is a forum for the DC.
No, my lord, it's a 6-seater area, my lord. Your lordship will kindly see the letter, my lord, issued by Additional Secretary Revenue Office. So,
He
Dima
can
Asa Autonomous.
approach Principal Secretary Lordship. He can approach Principal Secretary Lordship.
There is no statutory, my lord, rules as on that, my lord, they have framed, my lord. That is the thing, my lord, in this kind of matter, my lord, there was earlier also, my lord, I have approached in Honorable High Court has set aside. But there is no forum, they do not, my lord, provide the forum, my lord. Now, after this letter, your lordship will see, it's for vacation of land, my lord. Finally, consider my patta is in intact, my lord, 2023, my lord. And this Sojan Thousand, my lord, referred in the notice, he died in 2007. So
Yes,
that is
Mr.
without, my lord, jurisdiction. my lord.
Who's appearing for Dima Hasao?
Lordship, I am here.
What instruction?
Right now, I have been told that Lordship, he have he has got on a position excess land. Lordship. That
No, but who has conducted that? Whose instance?
Yes.
Lordship, that I don't know.
You get it, get your instruction, and issue notice to the respondents. Mr. C. Sharma appears for respondent 1,
1, 3, and 4.
1, 3, and 4. M
Two,
for respondent 2. Since the respondents are represented by the respective counsel, notices are waived. Now, obviously, the petitioner is aggrieved by the impugned notice issued by the additional secretary and revenue officer demands of autonomous council by the notice dated 28/2/2024. By the said notice, the petitioner has been asked to vacate the land which is stated to be under his possession in the authority. So, according to the petitioner, how much land you possess?
I have, my lord, 7 bigha, 2 kotha, and 8 lisa. I have annexed the patta.
7 bighas, 2 quotas, 8 lectures as per the patta issued to him. Therefore, impugned notice has been issued without conducting any. Did you participate in any survey?
No, my lord, nothing was done by them, my
Without
lord.
conducting any survey, and the same cannot be done. So, let the government council complete their instructions and furnish before the court by the next date. This the month of July. Notice on the interim grant. No steps be taken to evict the petitioner without leave of the court the next 8 weeks. Based on 19 July. 19.
Obliged.
Obliged.
May I please, Lordship? My lord, my lord, limited grievance of the petitioner is there. My lord, kindly see page 13, Lordship, of this petition. My lord, a plot of land measuring 3 bigha, 3 kata 13 lessa. Well, in the name of the petitioner is serial number 6, Lordship. Bhogiram. Bhogiram Uja, Lordship. Well, this plot, my lord, the petitioner, my lord, wanted to, my lord, mutate the name of the petitioner in place of his father, late father, Lordship. My lord, the circle officer, my lord, told him that this DAG number is fake. Thereafter, my lord, the petitioner, my lord, approached the deputy commissioner, kindly see the at page 39, Lordship. This is a replication, my lord, for clarification whether that plot is, that number is take or not, lordship. The deputy commissioner by letter dated 41, lordship, recommended this application, forwarded this application to the circle officer, my lord, to make an inquiry and take necessary steps, lordship, as per law. My lord, nothing has been taken up. Thereafter also, my lord, the petitioner submitted an application for mutation. That is at page 42, lordship. My lord, nothing is taken, no steps, no step is yet taken, lordship. My lord, the circle officer is sitting over the matter, lordship. So petitioner simple, my lord, prayer, my lord, it may be directed to be disposed of, my lord, after hearing.
First, let them get the instruction.
Yes, lord.
Because of the petitioner, if that is application dated 4/3/2024 file. So the circle officer work on a revenue circle seeking mutation of land covered by patta number 73,110 falling under tag number 870.1152 under more Dahi, which the petitioner claims to be under has not been investigated, has not been disposed of. He therefore seeks the direction to the state. Seeks a direction to the circle of Para implement hormone and a government advocate. Appears on
3 and 4, I will.
respondent
2, 3 and 4. One is revenue, my.
2, 3 and 4. MSPR Monto. Government advocate will obtain the status of the representation stated by the reputation by the next day. And the period stating on 24th.
Lord, you oblige. Item number 20.
None appears. Pass over.
Pass over. I think item number 1.
Yes, Mr. Mondal.
Maybe. My lord, I have been instructed, my lord, the bar association has been registered.
File it.
Yes, I will file, my lord, additional affidavit.
File it. Mr. M.U. Mondal and counsel hearing for the writ petitioner submits that you'd like to file an affidavit bringing forward the status of the bar association as to whether it is a registered body. Let the matter be listed after 3 weeks.
After a week, in the meantime, I will
Be listed after MSM Mormon appears to the response. List report.
oblige.
Item 20.
Yes.
Please, Lordship. My lord, matter pertains to the AGM and election of a cooperative society, my lord. The earlier, some of the petitions had approached this honorable court, my lord, challenging the earlier AGM and election on the cancellation of the nomination and also, my lord, non-compliance of the provision of 26(3) without correction of the voter list, the AGM was held. The earlier orders, my lord, I have annexed in this honorable court. This honorable court, my lord, have demanded the matter to the registrar, my lord, and my lord, my lord, instead the registrar had remanded to the assistant registrar, my lord, page number, my lord, 32 was the earlier order, my lord, and 38 was the order of the registrar, assistant registrar cooperative societies, my lord. Then, my lord, this honorable court again held in page number 40 that the assistant registrar had no jurisdiction and he is not an authority, election authority, as per election rule 2019, and it is the registrar, my lord, who will decide the dispute after inquiry, the election disputes, my lord. Then, my lord, the assistant registrar heard the matter, my lord, and by order dated 18/9, page number 56, my lord, 18/9/23.
Here.
Page number 56, the registrar had, my lord, set aside the approval of the AGM, my lord, page number 56. On 18/9/23, and my lord, on the ground that, my lord, though the electoral rule was not interfered, but, my lord, the cancellation of the nomination was held illegal, my lord, as per section 40. Section 42, my lord, as per section 42, the members who contest the election, at least 2 annual general meeting should attend in the last 5 years. But in the instant case, there was no annual general meeting for which the registrar interfered. And, my lord, page number 57 is the, my lord, operative part, my lord, of the registrar order. The registrar had held that the cancellation nomination is, my lord, is illegal. So he remanded back the last paragraph, my lord, to the AGM for holding the AGM by appointing a one-man committee, my lord. Accordingly, my lord, the one-man committee constituted, and, my lord, notice for election was again held, my lord, but there was no proper correction of the voter list, my lord, and, my lord, though the petition did not get any chance for challenging the voter list, they, my lord, participated in the election. But what happened in the election, my lord, the impersonation was there, my lord. Several persons, my lord, dead voters cast their votes, my lord, and, my lord, I have annexed the, my lord, card, identity card from page number 67 onwards, my lord. Some of the members, my lord, the photographs are of the not the voters, my lord. These voters are dead voters, my lord. So their family members or some other persons paste their photos and cast their votes, my lord. My lord, I have in paragraph number, my lord, of my petition, from paragraph number 13, my lord, paragraph number 16 on 16, my lord, I have mentioned all these, my lord, anomalies. After the registrar hearing, my lord, the matter, had directed the secretary to provide the marked copies of the electoral rule, my lord. Page number, my lord, 87. During hearing, the registrar had directed, my lord, because I had again approved the registrar, my lord, under section 27 of the election rule, and page number 87, my lord, the last paragraph.
On what basis, what is the evidence to show that some dead persons were
My lord,
impersonated?
my lord, the registrar had directed to the secretary and RHS to provide the marked copies of the electoral rule, which was
What copies?
marked copies, my lord, the electoral rule. The person attended the voting, but without providing marked copy, they provided the attendance register who had attended for voting, my lord, attendance sheet. That was provided, my lord, without certified, my lord. And from this attendance sheet, my lord, we had found that more than 100 persons, my lord, impersonation name. There are, I have mentioned in paragraph number 16, my lord, serial number and members number, the manipulation, my lord, paragraph number 16. After getting the, my lord, the attendance sheet which was provided as per the registrar's order, my lord. Page number.
We issue notice here, let them obtain the instructions here.
Obligement. Till then, my lord,
Then what?
my lord, the approval given to the, my lord, new body, maybe, my lord.
Not by way of an interim order. Not by way of an.
Well, it was clear, my lord, the
Unless we find that, yes, whatever you are alleging, at least a part of it is correct. Which shows prima facie that the election was not conducted as per the.
Yeah, it is right. The record was before the registrar, man. Registrar produced the original record, man.
Let them get the instruction.
Obliged. Notice may be issued.
Counsel for the party. The pub
Lordship,
for
Corporation Department.
the cooperation department. Hearing for respondents number 1, 3, 4. 7 also,
6, 7, my lord.
6, 7. 6, 7. You are appearing for
Capital respondent number 8.
only 8.
8 only.
Council appears for respondent number 8. Steps on all the other respondents to be taken by registered post AD as well as the usual course within one period of 1 week from today. The prayer for interim will be considered upon return of service of the respondents. The respondents, meanwhile, they complete their instructions and file necessary affidavit if so advised. List after return to the
Obliged.
Obliged.
Alright.
After motion item 21. Notice in this matter was issued on 22/6/2023. As per Office Note 21/5/2023/2024. Steps of respondent 3 and 4 have not been taken. Council. So, none appears for the registry will inform the council about the audit. The petitioners are permitted 10 days further time to take steps on respondents in terms of the earlier order passed by the court. Copy of this order, the property notice of receipt registrar division. Admission item 50.
May I please, Your Lordship? In this case, what happened, Your Lordship, the son of the petitioner died due to motor vehicle accident hit by unknown vehicle. And thereafter, Your Lordship, petitioner approached by filing an application before the District Legal Services Authority, and which has been pending. And after the receipt of the application of the petitioner, District Legal Services Authority issue notice to the petitioner, and accordingly petitioner appear before the honorable before the office of the District Legal Services Authority and submit relevant document. In this regard, Your Lordship, the respondent number 4 file an additional affidavit, Your Lordship, on 2/1/23, Your Lordship. Sorry, Lord, 18 November of 2022.
नहीं 4/1/22
There is definite.
additional affidavit. Two affidavits at additional affidavit is 4/1/22. And 4/1/24
There is two additional affidavit in opposition. One is 8 of December 22 and one is 18 November 22. Yeah.
Is the petitioner not entitled for payment under the compensation scheme?
Yes, my lord.
State government?
Yes, my lord. So he doesn't come under the notification of 2F. That is our stand in the affidavit, my lord. But accordingly, he has paid that ex gratia amount, which we have brought by addition in our
It's
additional
already been
affidavit.
paid.
It's already been paid. As he is not entitled under 2F, my lord, so district legal service authorities take up with the other authorities in the administrative side, my lord. Accordingly, They have arranged that 2 lakhs, my lord.
Is the scheme enclosed here?
Yes, my lord, in the affidavit, in the petition itself. the
Page
scheme is-
29, your lord.
Page 29.
Itu same instruction more south of right. ते तुम्हाला पण दिले होते. आणि video copy. No, no, no. I've seen him deals in a report.
Lordship.
Hmm.
For a movement, if your lordship will find at page 30 of our petition, middle portion, your lordship, eligibility criteria, lordship, paragraph number 4, your lordship, merit, your lordship, where the preparator of heinous crime is not traceable or cause punishable after trial, but the victim is identifiable and the victim has to be rehabilitated physically and mentally. Such victim may also apply for grant of compensation under subsection so and so, your lordship, of this act.
Correct. Absolutely correct.
And
57A, but
as
never-
per their in affidavit in opposition, they have stated that part was, your lordship, at page 29, definition portion, 2F, your lordship. Victim means a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heirs.
Has any criminal proceedings been initiated somewhere? FIR? Must be.
Lordship, in this case, FR submitted.
Huh?
FR already submitted.
FR submitted.
Yes, because unknown vehicle was hit. We have
The
annexed.
accused was never identified in the matter, your lordships, and therefore an FR was submitted in the case. The matter was closed.
What about this clause 4? Oh, 4.
Lordships, that is for the court to decide that where there the this DLSA or the ASLSA cannot say in any manner. It is for that court to decide whether compensation ought to have been granted under section 357A of the CRPC at that relevant point of time. At the time of trial, when the proceeding was going on, that discretion lies with the trial court, your lordships. So in this writ petition, whether my learned friend can rely upon this particular clause, in my respectful submission, might be a little difficult, your lordships. Now, the difficulty is that the matter never went to trial because of the FR which was submitted. Be that as it may, your lordships, the fact remains that the petitioner has already availed more than 2 lakhs rupees, or almost 2 lakhs rupees, as per the affidavit filed by the DLSA, and my instructions also, your lordships. And several assistance have been given to the petitioner.
Lordship,
Your lordships will kindly take up the instructions which are just placed before your lordships.
Yes.
Lordships will kindly take up page 2 of that,
Page
of the
2.
instructions which I have just placed before your lordships.
Okay.
Page 2.
Yes.
Hence, after, I'm reading paragraph 1, hence, after discussion with the petitioner, the secretary have decided to engage a legal aid counsel specialized for the accident claim for initiating the process of compensation under the MACT. So that assistance is also being provided to the petitioner, apart from the 2 lakhs which has already been granted as ex gratia under the disaster management.
How will you ensure claim under MSCP?
No, we are not ensuring it. We are giving her all possible assistance by giving her a paralegal
The
volunteer.
driver is not identified. Parties are not identified.
That is the difficult, Lordship. We are trying to. Lordship,
How will you proceed under MSCP?
because he was riding a bike, your lordships, that the vehicle number is there, and the fact that he was hit by another vehicle is also on record. So perhaps that could be one of the reasons why, in fact, that is mentioned in the affidavit filed by the authorities. No, Your Lordship. In this instruction itself, at page 1, first page, Your Lordship, last paragraph. However, after going through the copies of the final report submitted by the police, it seems that there was also involvement of one motorcycle bearing number so and so on which the deceased victim was riding and was dashed by the offending unknown vehicle, resulting into the death of the victim. Thus, there might be a thin probability of getting some compensation by the dependent or next of kin from the MACT. It is under this provision that they're trying to see if any assistance can be granted to the petitioner.
But no proceeding has been initiated as on date.
No, I'm not aware, Your Lordship. They have not said whether a proceeding has been initiated under MACT or not. That I'm
No,
not
Lordship.
not
As
aware.
per
Your
my
Lordship.
inspection, there is no inspection.
Yes. What do you say regarding the fact that this 357A scheme
Lordship.
is applicable in respect of victims
Yes, Lordship.
where the matter has proceeded for trial?
Lordship, so far as I remember, Your Lordship, for a movement, Your Lordship, if Lordship will find at page 30, paragraph 5.1, Your Lordship, procedure for grant of compensation, Your
Yes.
Lordship, here, one Lordship. Whenever recommendation is made by the court or
court.
Yes, Lordship.
Which court?
Trial court.
Right.
Yeah.
Then any recommendation made?
That part was if any case sentence, then court will initiate it to grant that part, Your Lordship. And two, Your Lordship. So, Lordship, can give me for time for further study. Give me for some time for further study, Your Lordship. Because I'm confused right now. Actually, I was.
You are confused.
Yes,
So
Lordship.
you
I
have
was
to give
study,
time.
but I forget.
No, if you are confused, then you better take time. You don't
Lordship,
confuse us.
Lordship.
Matters then referred to be taken up after 2 weeks,
Lordship.
enabling the learned counsel for the petitioner to complete the instruction. You read section 357 capital A.
Yes, Lord.
This is the source of power under which the scheme is been formulated. And see, MSM Bourbon for state are for
Respondent number 2, Your Lordship.
respondent. Yeah.
Deplore.
Section 23.
May please use the Lordship. In this matter, on the last date, we were directed to file an affidavit by bringing additional pleadings. Some records are yet to be traced out. Can it be on 24/5, Your Lordship? 24/6, Your Lordship? Can it be on 24/6? We are yet to file the affidavit.
You have it after July. Counsel for the petitioner seeks further time to file the he praised for 3 weeks time. Mr. P.J. Talukdar, London Senior Counsel, represents the Revenue Department.
No.
Are you appearing for revenue?
No.
State.
State.
Assisted by Ms.
I'm listening.
P.R. Mohan for report. Matter be listed after 3 weeks.
Interim to continue.
What interim is there? There was no interim in the last order.
Interim was there by order dated 18/11/22.
It's not continued by 9/5.
It was continued, Lordship.
You see the order. It's not continued by 9/5. It's in the month of July.
I'll apply.
Yes.
May it please, Lordships. Lordship, in this matter, the petitioner, the respondent had issued an invitation to bid for auction of a property. And the petitioners herein had contested in the bid, and they came out, they participated and they won in the auction process. The property, with regard to the property, the entire amount of 55 lakhs was paid on 27/11/2014 by way of demand draft. After the demand draft
You
was submitted,
participated, you bidded for the property.
yes, Lordship. So after the deposit of the same, a sale certificate was issued by the respondent bank on 20th of February 2015. And in the said sale certificate, they have acknowledged that they have received the entire sale price of rupees 55 lakhs. That was deposited in November 2014. Thereafter, my lord, the property was not handed over to the petitioners. And the respondents wrote a letter to the Deputy Commissioner Kamrup Metro, which is at Annexure 14, page number 43 of the petition. By virtue of this letter, the bank was requesting the Deputy Commissioner to assist them in getting the possession of the mortgaged land, which has been successfully sold to the petitioners herein. But when the police personnel went to assist the bank to get the possession of the property, the mortgager, Mr. Nabakumar Das, he had showed an order dated 2/1/2014 passed by the Honorable Civil Judge number 3, Kamrup, Guwahati 1, in a title suit. That title suit, Lordship, was with regards to execution of agreement to sell between the mortgager and a third party. The bank was not a party to the suit. We were not a party to the suit. And during the pendency of the title suit, this entire auction process has taken place. So in view of the fact that the injunction order was there from the court of Honorable Civil Judge number 3, the property, the possession of the property could not be taken over by the bank.
Where is that injunction order?
Injunction order, my lord, the order is at page 31.
Yes.
May I read the order, Lordship? This case has arisen out of it. Lordship?
Matter is presently pending before the trial.
No, my lord. What we have done is subsequent to the when we came to know about this particular title suit, the petitioners herein had filed a money suit. But another advocate was dealing with that particular matter, and subsequently we were engaged. So we filed an application for withdrawal of the money suit on the ground that a similar matter has been disposed of by this honorable court, wherein the bank had wherein this honorable court had directed the bank to pay the entire sum of money along with interest. So on the basis of that particular judgment, the money suit was withdrawn, and the withdrawal order is at page 74 of the petition. Parties are represented, heard both sides on petition number so and so filed by the plaintiffs under Order 23, Rule 1(3)B CPC for withdrawal of the suit with liberty to take recourse to appropriate alternative legal remedy on the grounds mentioned in the petition. Learned counsel for the defendants has raised no objection against the petition. On consideration, petition is allowed. The instant suit is disposed of upon withdrawal accordingly. Subsequent to the withdrawal of the money suit before the learned trial court, the instant writ petition has been filed. Now, my lord, after filing of the writ petition, the respondents have filed their affidavit in opposition. And in the affidavit in opposition, my lord, they are saying that the possession of the land was handed over to the petitioners, but since we did not take proper care of the property and we did not do any construction or anything of that sort on the property, that is why the
mortgager again encroached upon the property. My lord, first thing is there was already an injunction order of 2014 in the matter. So the question of getting possession of the land by the bank does not arise. Secondly, the letter which the bank has written to the deputy commissioner in 2016 clearly proves that the bank did not have the possession of the property in 2016 also. So if in 2016 the bank did not have the possession of the property and they were requesting for the same, the question of handing over the possession to the petitioners at the immediately after the auction does not arise.
When did the sale certificate, when was the sale certificate?
Sale certificate February 2015. February 2015, Lordship. Now, secondly, if I may take your Lordship to page 90, it is the affidavit in opposition of the respondents.
After the sale certificate was issued,
Lordship.
what steps did you take to request the bank to hand over the?
Lordship, verbally we had taken a number of steps. Apart from that, thereafter after the sale certificate was issued, we sent a letter, page 43. This was by the bank to the deputy commissioner upon verbal request to the bank.
This is
And
in
immediately 2016. Immediately thereafter, my lord, in 2017 itself, we filed the money suit
Money suit against whom?
against the bank.
Huh.
We filed money suit against the bank, which was pending, and the suit was ultimately withdrawn in
For
2000.
recovery of the amount you have paid for the
Lordship,
property.
Lordship, along with interest.
Then
The suit was pending. It was at the evidence stage. At that point of time, we filed the withdrawal petition, and the withdrawal petition was allowed with liberty to approach this honorable court. And immediately thereafter, the order of withdrawal was passed on 1st December 2022. And in 2023,
where is the order of the?
withdrawal, my lord?
Yes.
Withdrawal order is at page 74. I have also enclosed the petition which I had filed. Withdrawal order, page 74.
Yes.
Immediately after withdrawal of the money suit, we filed the writ petition before this honorable court in 2023. The withdrawal order is dated 1st December 2022.
Yes.
Immediately thereafter, we approached this honorable court. And now in the affidavit in opposition, the bank has agreed to the fact that this honorable court shall allow the respondent bank 6 months time to execute the sale deed and hand over the possession of the said plot of land to the petitioner. It is at page 90, my lord, paragraph 16.
Yes.
If I may, if your lordship has found it, paragraph 16, it is the 6th line from the bottom of paragraph 16.
Yes.
However, this honorable court shall allow the respondent bank 6 months time to execute the sale deed and hand over the possession of the said plot of land to the petitioner. Now, my lord, as soon as this affidavit in opposition was filed, this was filed, my lord, on 6th February 2024. So, immediately upon receipt of the copy of the affidavit in opposition, the petitioners approached the respondent bank, which is in the rejoinder, my lord, page 112.
Yes.
Page 112, if I may read, to the administrator, Industrial Cooperative Bank Limited, reference this particular writ petition, my lord. With reference to the above case, we have received a copy of the affidavit in opposition filed by you on behalf of Industrial Cooperative Bank Limited on 7/2/2024, wherein in paragraph 7 of the affidavit in opposition, you have stated that we are entitled to the plot of land measuring 2 kathas with one Assam type house standing thereon, covered by dag number so-and-so of KP Pata number so-and-so at village Medangaon under Mauza Beltola in the district of Kamrup Metro, Assam, since the title suit between Shri Dimbeshwar Kalita and Navakumar Das has been dismissed by order dated 24/3/2023. You are hereby requested to hand over the property to us and execute sale deed and complete other formalities within a period of 15 days so as to enable us to take necessary actions before the Honorable Guwahati High Court. To this letter, my lord, the bank has responded to the petitioner number 1. If I may take to the next page, my lord, page 113. It says, with reference to the subject cited above, we would like to inform you that since the matter is sub judice before the Honorable Guwahati High Court, it would be difficult for us to initiate any action on the plot of land without any prior intimation to the court. We are ready to execute the sale deed with you immediately, provided the Honorable Guwahati High Court directs the same to us. Now, my lord, since the bank is also agreeing that they are ready to execute the sale deed, my only humble prayer before this Honorable Court is that a timeline may be set within which the bank will hand over the possession of the property to us and also execute the sale deed. And we are ready to take over the possession of the property.
Yes, what do you say?
Like, as per the reply, we are ready to hand over the possession and we are ready to execute the sale deed. My lord may fix a timeline. We need some time to.
How much time?
My lord, we are praying for 6 months' time.
My lord, the matter is like the auction had taken place 10 years ago, my lord.
My
The
lord,
petitioners
because
have been waiting
we
for
were
10
not
years.
The party to the title suit that was filed. We got to know very late that there was a title suit pending with
Yes,
an injunction
because
order.
what timeline you want?
My lord, at the most 3 months, my lord. I will be reasonable. I will not be unreasonable.
6 months time, because why not? With regards to the sale permission and everything, also it takes some time before the.
All right, do it within 4 months. Giving you one more time. 4
Other
months?
than 5 months.
Huh?
5 months.
You're haggling for time.
My lord, that
because my lord, the sale obtaining the sale permission takes a lot of time.
Lord, they are a bank. Once the order of
Anyway,
the
you
court will be there, they will follow.
when did the sale take place?
October 2014, my lord.
14.
14.
Right.
My lord, there's one more thing. My lord asked in the initial part
Hmm.
whether what is the status of the title suit. That what is the status of the title suit, the injunction order, my lord?
My lord, with regard to that, the affidavit has already been filed by the bank stating that the title suit between the two parties
My lord,
has been dismissed.
If I may, my lord, on the date of filing of the affidavit in opposition, the title suit was dismissed for default. Thereafter, my lord, I just got to know in the morning while checking that it has been revoked and the title suit is once again going on. So, my lord, if there is a stay order which I'm not aware, the execution.
You were ready to make a commitment for 6 months.
Yes, my lord, but this is an information that came to us after filing of the affidavit in opposition.
Your lordship is aware, my lord.
You make your stand clear what you want to do. You're already on
My lord,
work.
I'm praying for some time to verify the status of the title suit. If there is
Lordship
an
will
injunction
kindly
order, I
This
should
should
bring
not
it
be
on.
contrary to your affidavit. Your affidavit, you have already made an
And I
agreement.
filed a certified copy of the order, ma'am.
Whatever you may have filed, but there is an affidavit on record.
Yes, my lord, because at that point
You
of
have given
time,
an undertaking to hand over the land within 6 months.
yes, because on 24/3/23, at the time of filing of this of the affidavit in opposition on 7th of February 2024, the title suit was dismissed for default at that point of time. Thereafter, in the month of May, it was revoked.
Fact remains that you're holding on to the petitioner's money. You refund it back with interest. End of the story.
My lord may just give me some time to verify this new fact.
No,
that
what
is coming
verify?
to light.
If it is an order restoring the suit will continue. We can't go on giving you endless time. You have taken over the money, sitting over the money for more than 2 years,
10 years, my lord.
10 years, and without any interest.
My lord, we are willing to repay the money if so need arises. But before that, my lord may give me just one opportunity to discuss the same with the bank because of this new development.
Lord, even if the
revocation
title
has
suit-
happened in the month of May of 2024, ma'am.
My
And
lord,
the dismissal
All right,
happened in
we take it up next week. You get your instructions.
Yes.
Lord, a date may be fixed, my lord.
Matter to be listed again on 14th
14.
of June. The counsel for the bank will obtain instructions as to the claims made by the writ petitioner for handing over physical possession of the land which was auctioned and purchased by the petitioner. Pursuant to the sale notice dated
Sale notice allowed February 2015. 2002-2015.
20/02/2015 and the sale certificate issued on,
Sale
that is the sale certificate.
Sorry, sale certificate is 20 02
Pursuant to the sale
2015.
certificate issued on 20/02/2015, or in the alternative, refund the money paid by the petitioner for the sale purchase along with bank interest. That will be listed accordingly, enabling the bank, counsel for the bank to repay.
Much need to oblige.
Item 25.
With your lordship, the matter has become infructuous.
Counsel for the petitioner submits that the matter has become infructuous according to the same stand dismissed as infructuous in prim orders if any stand vacated and the ayes are also vacated.
Highly obliged.
Counsel for, give your name to and to counsel.
Respondent number 19.
Give your name. Court master. Huh? You have filed a caveat.
Yes.
A caveat number so and so, stand start. Counsel. What is your name?
H. Cluster.
H. Tosco. Appear to the caveat. Caveat stand start. And subsequently the writ petition stand dismissed or by the counsel. Yes.
Obliged lordship.
Item 26.
May I please repeat? Not, we had a registered pharmacist under the Assam Pharmacist Council. Basic grievance is that our pharmacy council's license was cancelled on various dates, my lord. Now, there is a clause, my lord, the alternative remedy was available for moving to the appellate authority under 36(3), 36(4) of the Pharmacist Act. But the grievance was that the communication of decision of taking by the executive committee and also confirmation made by the state council was lately communicated to us, and by the time the period of 30 days has been over. So on that basis, my lord, the division bench of this honorable court has granted the liberty to similarly situated persons to move the appellate forum, and then directed the authority to provide the executive committee resolution as well as the state council confirmation order, my lord. So, and on that basis, similar, coordinate bench was also disposed on the basis of the writ appeal, my lord. I just like to place those.
Yes, respondent, what do you say? Who's for respondents here?
Pharmacy council.
Who's pharmacy council, who's appearing from pharmacy council?
D. Gogol was appeared earlier, and last occasion, Opomano, D. Opomano was present.
Where is the health standing council?
Doctor will take up after some time, so then I'll call
Yes, after some time.
my lord.
Item 27. Yeah.
So in this case, my lord, although my lord, there is an interim order, my lord, on 21/7/2023, my lord. On the very day, my lord, the eviction drive was carried out and demolished or building.
Yes.
Well, the building over which the build, the was situated, my lord, the land is our, my lord, the building was constructed with due permission from the municipal authority. And in Patta land, but the authority has come and measured the, my lord, length, my lord, 50 feet from the middle side of the road, my lord. Although the
Then let the respondents, you file your affidavit.
I have not received it.
File your affidavit. Heard learned counsel for the party. Representing the subjects that instruction. You write a can or what come and advocate appearing for the respondent. Assisting Mr. D. That we are instructed like to file, complete the instructions and file necessary affidavit. Praise for 3 weeks time. And be listed after 3 weeks. It's not. Prayer made not objected by council. Yes.
Yeah, the one. Yeah. Wait, please. Meta potential non-payment of land compensation to the petitioner. Respondent number 2 has filed affidavit in opposition. And the other respondents are yet to file a response file.
What is respondent number 2?
NHIDCL, my lord. NHIDCL, my lord.
Extra
you-
copies.
You have
we are yet
deposited
to
the
receive.
amount.
Yes, lord, we have deposited the amount of 88,84,920 before the Kala account.
Extra copies are not yet received, my lord.
Let's have
Notice
right
could
now.
not be sent.
Counsel for the petitioner undertakes to serve extra copies on the council hearing. On the government council hearing for the state government. Mr. Arpital represents the National Highway Authority. Is Kala also a party separately?
My lord.
Is Kala is made a party? No.
Yes, lord, respondent of 5, my lord. Case 4.
5 is Competent
on appearing on behalf of respondent number 2, sorry, 1, 2,
appearing
1,
for
2, and 5. MSPR Mohanto for respondent 3.
five, I am appearing, my lord.
You are appearing.
Yes, my lord.
I am for only two.
4, 5, and 6, I am appearing. my
5,
lord.
6. 6
Three is
that
revenue.
extra copies have not been furnished. The counsel for the petitioner undertakes to furnish extra copies
Today, sir.
course of the week. Matter be listed after 2 weeks, enabling the respondent with the extra. The National Highway Authority has filed their affidavit where there is an appointment made at an amount of rupees 88 lakhs.
88 lakhs. 84,920.
88, 84,
920.
920 has been deposited the account of the
Kalamaya.
Respondent 5.
account of the competent authority of land acquisition.
3 weeks may be granted for filing affidavit. 3 weeks.
3 weeks time to be listed after 3 weeks.
Alright.
Your lordship has heard the matter at length.
Hmm.
Order dated 29 to 24 May kindly be seen. There is already an order from the coordinate branch that the petitioners are entitled to get benefit under section 16(5) of the Right to Information Act.
Yes.
Allot me kindly, there are additional affidavit your lordship will kindly see, paragraph 4. I think it is page 83, it will be at page 84. May I just read, man?
Yes.
That the deponent begs to state that former State Information Commissioner, Mr. Das, was an IAS officer of 1982 batch. He retired from service in 2014 as additional chief secretary before joining as State Information Commissioner, State Chief Information Commissioner. He served as SCC for a period of 5 years from 14 to 2019, and after retiring from the post of Chief Information Commissioner, Assam Information Commission, he applied for special additional pension and gratuity, which was processed by department, taking cue from the Central Information Commission file number so-and-so dated so-and-so. Special additional pension was fixed subject to maximum ceiling of rupees 15 lakhs per annum. In case of the petitioner, it will be about, I think, 12 lakhs, 5,000 or so. He is getting about 11 lakhs now. After approval from the principal secretary department, this sanction letter number so and so was sent to accountant general for granting the same to Sri Das. But the deponent further states that since SCSI Sri Mr. Das retired from the post of additional chief secretary in 2014, whereas Sri Bosumatari, ex-IAS, retired as an officer on special duty in the office of the Principal Accountant General Guwahati on 31/12/14. As such, according to the Central Information Commission's order number so and so, benefits of additional pensions, etc., can be availed by those who worked in the rank equivalent to that of the election commissioner, Government of India. Here, in this present case, the petitioner, Mr. Bosumatari, was an ex-IAS and retired as an officer on special duty in the office of Principal Accountant General, Guwahati on 31/12/14. After his retirement, he served as State Information Commissioner, and before joining this post, his rank was not equivalent to that of the Election Commissioner of India, but in case of Mr. Das, his rank was equivalent to that of the as he retired as Additional Chief Secretary. It is pertinent to mention that the petitioner did not retire as Chief Secretary or from an equivalent. Same thing they are saying, that you are not the Chief Secretary or from an equivalent rank office of the state. Views of Judicial Department of was also sought earlier, and as per earlier view of LR Assam dated so and so, the retirement benefit of facilities of telephone and security assistance in respect of petitioner was accordingly rejected. As such, on perusal of the available records and the prescribed provisions, it can be ascertained that both cases are different. So this is how they distinguish. Your Lordship will kindly see how they have created this post. Page 58. This is how Mr. Das Malas, who was the
No,
Chief
let
Information
us-
Commissioner.
Let us see your appointment order. Where is your appointment?
Yes. Page 36. Governor of Assam is pleased to appoint so and so as the State Information Commissioner in the state in the Assam State Information Commission constituted by so and so dated 6/10/2005 under section 15(3) of Right to Information Act 2005 enacted by so and so. He shall have to take vote of affirmations subscribing before the governor or any other person authorized by him as per form prescribed for the purpose in the first schedule as per section 16(3) of the Act before entering the office of the State Information Commissioner Assam. His term of office and conditions of service will be regulated as per provisions of section 16 of the Act. Now, section 16, may I just take your Lordship through section 16 once again? And before that, if I take your Lordship through section 13, the old version of the section 13, my lord. 13(5)
Of the
Right to Information Act.
right to information.
But here no, what should I do? My lord, it was amended in the year
2005.
Yes, it was amended in the year 2019, and unamended portion, your Lordship will get it below, man. Section 13, 5, my lord. These salaries and allowances payable to and other terms and conditions of service of the Chief Information Commissioner shall be that, this is central, my lord, is that of the Chief Election Commissioner, and an Information Commissioner shall be that of the State Election Commission, provided that if the Chief Information Commissioner or the Information Commissioner at the time of his appointment is in receipt of a pension other than a disability or wound pension in respect of any previous service under the Government of India or under the Government of State, his salary in respect of the service as the Chief Information Commissioner or an Information Commissioner shall be reduced So that is the provision that the Chief Information Commissioner will get the as that of the Chief Election Commissioner, and Information Commissioner shall be that of the Election Commission. So that is the salary structure.
Petitioner was appointed
As the state, my lord, appointed a State Information
State
Commission.
Information.
Now 16.5, your lordship, can you see? This is in respect of the central. Now 16.5 in respect of the petitioner. My lord, below your lordship will give, if it was 2019, it was amended. The salaries and allowances payable to and other terms and conditions of service of the State Chief Information Commissioner shall be the same as that of the Election Commissioner. So this facility has been provided to Mr. Himanshu Das.
The provision under B.
Yes, no, provision under A.
A.
The State Chief Information Commissioner shall be that as that of the Election Commissioner. So the same benefit was given to Mr. Das, who was the State Chief Information Commissioner. Now, in respect of the petitioner, under the State Information Commissioner shall be the same as that of the state of the Chief Secretary to the state government. Now they are saying that he is not IAS, he is not the Chief Secretary, therefore we have not given. But in respect of the State Chief Information Commissioner, they have given the additional benefit. Whatever the benefit is accrued to the accruable or accrued to the Election Commission, the same benefit has been given to them. Now your lordship will kindly see page 40. Benefit, whatever is accruable to the State Chief Information Commissioner under provision of 16.5. There, my lord, they have provided everything, including additional the pension and the gratuity. And this is in respect of the Chief Information Commissioner.
Yes.
Page 401.
40.
Yes. This is in respect of the Central Information Commission. May I just read one? Consequent upon the revisions of pay and allowances of the Chief Election Commissioner of India and the other election commissioners of India pursuant to the issue of High Court and Supreme Court judges, salaries and Act 2018, the pay and allowances of the Chief Information Commissioners and Information Commissioners have been revised by number so-and-so 2018. Further to the revisions and implementations of salary and pension provision for upper limit of additional pension and gratuity benefit to the Chief Election Commissioner of India and other election commissioners of India as adopted from the notified High Court and Supreme Court judges, Amendment Act 2018, the pension provision for upper limits of additional pension and gratuity benefits to retired Chief Information Commissioner and Information Commissioners are revised with effect from 2016. So therefore, in terms of provisions of Section 13(5) of the Right to Information Act, revision of pay provisions of upper limit of additional pension and gratuity of retired Chief Information Commissioners and Information Commissioners are revised with effect from 2016 as under. So these are the benefits provided to the Chief Election, the Information Commissioner and the Information Commissioner Central in pursuant to.
So you are being denied mainly because you are not an IAS officer.
No, then I am not retired as a Chief Secretary. This is what this.
Yes.
But that is not the provision of law, as I have shown, my lord. And I also wanted to show, my lord, page 49.
Yes.
This is a letter from the Secretary Assam Information Commission. With reference to the subject cited above, I am directed to forward here with the query received from the AR and T Department dispute regarding additional pension and gratuity. Therefore, you are requested to kindly furnish the reply as asked from. So the reply was given at page 50.
8,
50.
50. Then
Whatever is, but they have not done anything, madam. They said, madam, additional pension and gratuity were rejected, page 52. With reference to cited above, I am directed to inform you that grant of additional pension and gratuity in respect of Pinwell Busumutari, former State Information Commissioner, has been regretted. So now, as per this provision, Chief Secretary, he is equivalent to Chief Secretary. Chief Secretary is entitled to a post of telephone and security assistance with fixed pay. That your lordship will get it at page 55, which was created in the year 2010. Governor Assam, after due consideration, he is entitled to this also. This also they have denied. Even medical allowances also, my lord, as that of the Chief Secretary, they will get. To that extent, my lord, I have given a judgment because they were not giving the benefit of medical allowances as that of the Chief Secretary. So the matter went to Kerala at Ernakulam. My lord, I have given a judgment 2023 SCC Online Kerala 2449.
Umanathan Pillai.
Simanathan Pillai.
Yes.
Paragraph 2, my lord. The grievance of the petitioner is that while section 16(5) of the Right to Information Act provides that the salaries and allowances payable to and other terms and conditions of service of the State Information Commissioner shall be the same as that of the Chief Secretary to the state government, the petitioners have been denied the benefit of All India Services Medical Facilities Scheme 2020 applicable to the Chief Secretaries on the ground that the Chief Secretary becomes eligible for All India Service Medical Facilities Scheme 2020 only by reason of him being a member of All India Service. The argument of the respondents is that since the commissioners under the RTI Act are not members of the All India Service, the All India Service Scheme 2020 will not ipso facto apply to the petitioner. So ultimately, my lord, court directed, no, you'll have to provide it. All these paragraphs are important. Paragraph 2, 6, 7, 12, 14, 15, 20, all this, my lord, 20, 21, with 22, 23, and 24. For 24, for all the above reasons, I find that Exhibit P12 order passed by the respondent number 1 cannot stand the scrutiny of law. Exhibit P12 is therefore set aside. There will be a consequential direction to the respondents to extend to the petitioners medical benefits on par with the benefits available under the All India Services Scheme 2020 from 1/4/20, the date on which the scheme was introduced and was made applicable to the Chief Secretary to the state government. Consequential benefit, if any, to the petitioner shall be paid within a period of 2 months. So after discussing all the provisions of the RTI Act and all, this was the provision. And your lordship will kindly see, if your lordship sees that 16(5), again, once again, I have read it, 16(5), they are to get the benefit of the Chief Secretary. Once my lord, a person becomes, hold the post of the State Information Commission. So therefore, and it has been held by this court, my lord, in the earlier litigations, earlier round of litigations, that your lordship will find it at page 59. Your lordship has already noted. Relevant is at page 63. May I read it?
Yes.
In view of the legal fiction under Section 16(5) of the RTI Act 2005. Your Lordship has also noted in the earlier order, wherein it is a statutory provision that the salaries and allowances payable and the other terms and conditions of service of the State Information Commissioner shall be as that of the Chief Secretary of the State. The stand of the respondents that as the two writ petitioners have neither served as Chief Secretary nor in the rank equivalent to Chief Secretaries, they would be disentitled to the benefits of salaries and allowances, and other benefits of that of the Chief Secretaries of the State would be unacceptable. So it has been already a finding is there. In law, in as much as by virtue of the legal fiction under section 16(5), they would be so entitled as statutory provided. Accordingly, the respondents are directed to pass a reasoned order on the claim of the two writ petitioners for their service benefits, including retirement benefit and pension, if applicable, in the same terms and conditions as that of the Chief Secretary to the Government of Assam. There is a direction now they are saying, relying on the judgment passed by this by the division bench of this Honorable Court, which stands on a totally different footing, madam. That is 2022 1 GLT. Impugn order is, my lord, at page 65. Page 68, my lord, if I read. Basically, 68, may I read? Second, third paragraph. Now it is required to be examined as to whether after retirement from the post of State Information Commissioner, your Lordship has noted, my lord, in the additional affidavit and the documents which I have annexed in the writ petition, that the gratuity and other benefits have been given to the Chief Information Commissioner. Writ petitioner would be entitled to retirement benefit as that of the Chief Secretary of the State Government. The aforesaid writ petitioner, Mr. Bosumutari, has demitted office as State Information Commissioner on 31/12/19. At that relevant point of time, the Chief Secretaries to the Government of Assam were paid pensions under the provisions of the Central Civil Services Pension Rules 1972. A reading of the provisions of the Central Civil Services Pension Rules 72, more particularly Rule 49, shows that in order to entitle for pension, there is also a corresponding requirement of a minimum qualifying service for the person concerned to have served, and the minimum qualifying service would be 10 years. But as per the provisions of the RTI Act relating to appointment of the State Information Commissioner, it is found that the term of appointment is for a period of 5 years, and therefore it has to be understood that the minimum qualifying period of 10 years of service would not be satisfied in the case of a State Information Commission. Under the provisions of Section 16 of the RTI Act 2005, there is no provision for reappointment of the State Information Commissioner. Hence, under the scheme of the Act, RTI Act, it is to be understood that a State Information Commissioner holds office for a period of 5 years, and therefore she does not meet the requirement of minimum 10 years of qualifying service as required under the Central Government Service Pension Rules 1972. In this regard, the judgment and order dated so and so passed by the division bench of this court, of this honorable court, in so and so, reported in so and so. In the said case, the present issue in hand, whether a retired State Information Commissioner is entitled to receive proportional retirement benefit at par with the retired Chief Secretary of the state, was examined by the division bench of the Honorable Court. And upon consideration of the materials on record, the Honorable High Court rejected the claim of the petitioner. The relevant portion of the said judgment and order dated so and so, passed by the division bench of the Honorable Guwahati High Court so and so, are quoted here. So accordingly, my lord, page 70, therefore, applying the aforesaid reasoning and relying on the aforesaid judgment and order dated so and so in WPC number so and so, it is decided that the above mentioned writ petitioner, Sri Bosumotari, who demitted the office of the State Information Commissioner on 31/12/2019, is not entitled to receive retirement benefit equivalent to the retirement benefit of the Chief Secretary.
Where is the tenure of the office mentioned?
5 years.
Where?
But I think it's 16/5 on this thing. Well, while deciding this, while giving the reasoning, your lordship will kindly see, they have totally overlooked the proviso to the terms, to the section. Paragraph 16,
Where is the tenure?
section 16. The State Information Commissioner shall hold office for such term as may be prescribed by the center, shall not be eligible for reappointment. That is, no State Information Commissioner shall hold office at the age of 65. Right. Age limit is 65 years, my lord.
No, there is a reference of a term of 5 years.
5 years, because my lord, they are
Where is
appointed, normally, my lord, when the retired persons are appointed for period up to
I know,
65
but
years.
where
I'll try to find. I'll provide that information. But his terms of appointment is 5 years, and that
16(1), my lord. 16(1). Section 16, subsection 1.
this is what I have read now.
16(1) is the whole term for as may be prescribed.
Shall not be eligible for reappointment.
No, my lord, the pre-amended
For a term of 5 years.
5 years. The pre-amended part, my lord. Prior to amendment in 2019.
He served for how many terms?
5 years. 5 years.
One term.
My lord, that 16(5), your lordship will kindly see that proviso part, provided that if the State Chief Information Commissioner or the State Information Commissioner at the time of his appointment is in receipt of pension other than disability or wound pension in respect of any previous service under the Government of India or under the Government of the state, his salary in respect of the service as the State Information Commissioner or the State Information Commissioner shall be reduced by the amount of that pension, including any portion of pension which was commuted and pension equivalent of other forms of retirement benefits, excluding pension equivalent to of retirement gratuity. So whatever he is to get, my lord, that will be subtracted from the package receivable by the Chief Secretary. So therefore, my lord, on the face of it, my lord, the earlier order of the court shows, my lord, that the petitioner is entitled to all the salaries and allowances as applicable to the Chief Secretary. This is what the and
But,
salary.
what do you say about the division bench judgment?
Division bench judgment is, this is on a totally different footing, my lord. There, my lord, I think, my lord, they were not regular employees. They were appointed and they were claiming the chief equivalent State Information Commissioner should be treated as that of the State Information Chief Information Commission. Your lordship will get that. I think paragraph 24.
Also 16(5).
Yes, 16(5). State Information Commissioner, they were seeking the status of the State Chief Information Commissioner. So para 24, Your Lordship goes
Can you kindly come to para 8?
yes. Sir. A reading of provisions of section 16(5) of the Act goes to show that the State Chief Information Commissioner would be entitled to a salary and allowance and other terms and conditions of service, which would be as that of the election commissioners, whereas the State Information Commissioner would be entitled to a salary and allowances and other terms and conditions of service, which would be the same as that of the State Chief Secretary of to the state government. That is in the instant case the government of Arunachal Pradesh. Accordingly, we are required to examine as to what would be the salary and allowances payable and other terms and conditions of services of an election commissioner and that of the chief secretary. Well, I think if the lordship goes to paragraph 24.
No, so it does deal into the salary and allowances of state
Here the
information.
case is totally different. State Information Committee, that of the State Chief Information
No, no.
Commission. This is what, paragraph
It doesn't say so.
paragraph 24, your lordship will get it. Paragraph 24. In view of the above, we have to conclude that the relief sought for in this petition for a declaration that the state information commissioners are also entitled to a pensionary benefit as applicable to the state chief information commissioner in the state of Arunachal Pradesh cannot be accepted. The whole case is that, and it is not that they were employees of any government department or not. They were appointed as the state chief information commissioner, and ultimately they say that they want the benefit of the state chief information commissioner. That is their benefit. Paragraph 3, your lordship. Concluding part is that, and that is what the case is all about. So it cannot be equated with any other that you are not the chief secretary, so therefore you are not entitled to get the benefit of section 16(5). Paragraph 3, if I read, my lord, the writ petitioner was instituted in 2015, inter alia claiming that the petitioners having been appointed as state information commissioner would also be entitled to pension upon retirement on attaining the age of superannuation. These persons, who are they? This is not clear from the fact. To my understanding, they were not any government employees. One of the arguments set forth by the petitioners is that under the prevailing rules, the state chief information commissioner is paid a pension upon retiring from service, and according to the petitioners, there being no reasonable classification between the state chief information commissioner and that of the state information commissioner. Therefore, to maintain parity under Article 14 of the Constitution of India, the state information commissioner should also be declared to be entitled to the pensionary benefit as entitled to the state chief information commissioner. Although the writ petition was instituted in the year 2015, but during this pendency, in the meantime, the 4 petitioners have retired from the service in the year 2019. So matter was discussed, and ultimately, para 13, my lord. Para 13.
Yes.
A reading of the provisions of the CCS Pension Rules 1972 would go to show that in order to be entitled for pension, there is also a corresponding requirement of a minimum qualifying service for the person concerned to have served, and minimum qualifying service would be 10 years. But when we look at the terms of appointment of the State Information Commissioner, we find the term of appointment is for a period of 5 years, and therefore it has to be understood that the minimum qualifying for a period of 10 years would not be satisfied in the case of the State Information Commissioner. So therefore, my lord, here this is a case where the persons were appointed, they were not a government servant, and therefore they were seeking the benefit of the State Chief Information Commissioner, which has been denied by the government, by the division of the bench of this court.
Yes.
So now, as regard the benefit, I have already stated, my lord, in a similar case, my lord, that from the Kerala, when medical benefit was denied on the ground that he is not the chief secretary. So that has been provided. And under 16(5), they are entitled to get the provision, and in chief, state chief information commissioner has been given the all, including gratuity and including pension. So the petitioner should also be given. He was an IAS officer. He worked for about 35 years. Then thereafter, after his retirement, he was appointed. So he was getting pension. But additional pension, additional salary was given to the rank of the chief secretary. It has to continue. So therefore, and the facilities of the peon, this is whatever the benefit under 16(5), which is entitled under to the chief secretary, the same benefit has to be provided. So this is my case. Even in respect of medical allowance, whatever the chief secretary gets, he is also entitled by virtue of the provision of the chief secretary. And the court, learned single judge earlier round of case, it has been already held that the petitioner is entitled to get all the benefits under 16(5), and this cannot be denied to him. And one more, my lord, I just wanted to go through, if your lordship takes through. What is salary? Salary also includes pension. Section 17(1) of the IT Act, Income Tax Act. 16(5) says salary and allowances, and therefore the Chief Information Commissioner was provided the benefit. The salary and allowances payable to and other terms and conditions of service of the State Information Commissioner and the to other terms and conditions of service, the State Information Commissioner shall be the same as that of the Election Commission. He has been given all the benefit of the state. It is not because he is IAS or he is additional chief secretary, but he was appointed as the State Chief Information Commissioner. And now the State Information Commissioner shall be that as that of the Chief Secretary of the state government. So now this has been denied to him only on the ground that he is not an ISO. This cannot be done by this law doesn't say that. And I'm just pointing out, my lord, yesterday when I was going through what was the meaning of salary, I got the meaning under the Income Tax Act provided under section 17. Salary, perquisitions and profits in lieu of salary defined for the purpose of section 15 and 16 of this Act. Salary includes wages, any annuity or pension, and gratuity. May I provide this or the one page or the whole book?
No, we have it.
Section 17 of the IT Act. So therefore, my humble submission for this, my lord, and the
But
Kerala case.
How is this relevant in the context of?
No, because salary and allowances, because the section provides, because your lordship made how they.
Salary and allowance.
So what is the meaning of salary? It means also pensions, gratuity. This is what it says. So I thought.
That is for the purposes of assessing the income.
Assessing that is true, my lord. That is for the purpose of income. But for the purpose of showing, my lord, salary is also, it includes pension. It also includes gratuity.
That is for the purposes of deciding.
That is income. Yes.
Income,
That is
taxable
income.
income.
That is true. That is.
What would be included within your taxable?
Yes. But here in this case, salary and allowances payable, the salaries and allowances payable to and other terms and conditions service of, it also includes gratuity and.
Come back at two. We'll come back at
Lordship, Lordship, item 7 and 8, Lordship, they have not received the edit copy of.
Yes.
Now I'll just point out one. Lordship, can you take note of that 16(5)? Unamended portion, last. Lordship, may kindly note this. Last, 16(5) last proviso. Provided also that.
Yes.
Provided also that the salaries, allowances, and other conditions of service of the State Chief Information Commissioner and the State Information Commissioner shall not be varied to their disadvantage after their appointment. So therefore, if they are entitled to get the benefit of the chief secretaries as the State Chief Information Commissioner, so from the date of appointment, my lord, they are entitled to get the benefit of the benefit which the chief secretary is getting. So two benefits, my lord, which the chief secretary was getting at the point of time. One is that beyond, my lord, that I have shown that as per office memorandum dated 7/4/2010, page 55.
Yes.
Page 55.
Yes.
So this will continue. And the second one is that, my lord, gratuity and the additional pension. That additional pension was sought for from the petitioner. That is at page 48, my lord. Sorry, page 49.
49,
48, my lord.
48.
Yes. It says, my lord, with reference to the subject cited above, I am directed to reproduce the endorsement of PNG department regarding grant of additional pension and gratuity in respect of Bosumotari for former State Chief Information Commissioner. So these are the information short, and number 6 and 7, draft calculation sheet of revised additional pension and gratuity in respect of the incumbent, along with effective date, as was furnished in case of Sri R.S. Mushahari, ex-State Chief Information Commissioner, Assam. Then the calculation sheet, if your lordship takes into consideration page 50, 51. Additional pension, this is the calculation, you will get a 9,900 rupees extra, my lord. This last part, my lord, that additional pension, page 50, your lordship got.
Yes.
And the additional DCRG, that he will get some amount, he got it, and 7,02,000 he will get it. This is the calculation submitted to the authority, but they have rejected. Now coming to the case of that Kerala bench, my lord, I'll just like to point out paragraph 15, my lord. Kerala judgment. I'll just read one or two paragraphs so that what is clear in the figure. Page, not that paragraph 15.
Paragraph.
Married.
Yes.
It is therefore very evident the requirement that the state information commissioners should be paid salaries and allowances applicable to this chief secretary to this state government is a statutory mandate. In fact, the proviso under section 16(5) also makes it clear that the salaries and allowances and other conditions of service of the state chief information commissioner and the state information commissioner shall not be varied to their disadvantage after their appointment. That is the last proviso to 16(5). Now, paragraph 19, it is abundantly clear that payment of salary and other allowances to the state information commissioners on par with that of the chief secretary to the state government is a statutory mandate under subsection 5 of section 16 of the RTI Act. Therefore, even if the petitioners being information commissioners would not fall under within the ambit of Rule 2E of Exhibit 5, the P5 of All India Service Medical Facilities Scheme 2020, the petitioner will still be entitled to the benefit on par with Exhibit 5 scheme in view of the statutory mandate. So it is not necessary that one has to be an IAS officer, but if the provisions of the statute says that he will be treated as like that of the chief secretary, the facilities available to the chief secretary has to be provided to them. Now, para 20, while considering the issue agitated by the petitioners, it is necessary to examine and understand the relevance and importance of Section 16 in the RTI Act. The Minister of State in the Ministry of Personnel, Public Grievances and Pensions and Parliamentary Affairs, while moving the motions for considerations of RTI bill, said, "We wanted this to be known emphatically that the citizen of India was not only free to ask for information from the government, but also had a right to get it. The scope of this bill extends to all authorities and bodies under the constitutions or any other law, and inter alia includes all authorities under the central government, state governments and local bodies. The non-governmental organizations substantially funded directly or indirectly by the public funds also fall within the ambit of this bill. A duty has been cast in clause 4 of the bill on every public authority to suo motu provide to the public with the information as prescribed therein, so that the public has to take a minimum recourse to the use of this legislation for obtaining information. The procedure of securing information as provided in clause 6 of this bill prescribes a procedure which intentionally has been kept very simple. A citizen has to merely make a request to the concerned public information officer or assistant public information officer specifying the information sought by him. The fee payable shall be reasonable. We have provided that information shall be provided free of cost to citizens living below the poverty line. The Prime Minister intervened in the Lok Sabha debate on the Right to Information Bill and stated, Mr. Speaker, sir, efficient and effective institutions are the key to rapid economic and social development. Institutions which can translate promises into policies and actionable programs with the least possible cost and with the maximum possible efficiency. Institutions which can deliver on the promises made and convert, as the Honorable Finance Minister pointed out a few days ago while presenting the budget, outlays into outcomes. For institutions to be efficient and effective, they must function in a transparent, responsive and accountable manner. This is dependent not only on the process internal to the institutions, but also the ability of the citizens and external agencies to enforce their rights vis-a-vis this very institution. The Right to Information Bill, sir, will bring into force another right which will empower the citizens in this regard and ensure that our institutions and their functionaries discharge their duties in the desired manner. It will bring into effect a critical right for enforcing other rights and fill a vital gap in a citizen's framework of all rights. Now, paragraph 22, my lord, the law is applicable to all authorities and bodies under the constitutions or any other law, and all authorities under the central government and state government. The RTI Act, therefore, is a powerful weapon in the hands of ordinary citizens. The adjudicatory role is assigned to the Chief Information Commissioners and Information Commissioners under Section 18 to 20 of the Act. The RTI Act is given overwhelming effect under Section 22, and jurisdictions of courts is barred under Section 23. The Chief Information Commissioners and Information Commissioners are thus placed in a very high pedestal and high-powered position by the statute itself. This legislature therefore deemed it necessary to make a statutory mandate in Section 16(5)(b) that the salaries and allowances payable to and other terms and conditions of service of the State Information Commissioner shall be the same as that of the Chief Secretary. In the circumstances, the requirement under Section 16(5) cannot be permitted to be watered down under any pretext. I also find considerable force in the argument of the counsel for the petitioners that only a members of All India Service can be appointed as Chief Secretary to the state government, and hence the Chief Secretaries are entitled to the benefit of Scheme 2020, and consequently the petitioners are also entitled to the benefit. Exhibit P14, circular dated so and so, issued by the Government of India. Department of Personnel and Training provides that the principles regarding the promotions of members of All India Indian Administrative Service. Clause 6 of the principles guidelines provide that the zone of consideration for promotions of members of Indian Administrative Service would consist of all members of the service who have completed 30 years of service. Therefore, it is evident that only members of All India Service can be appointed as Chief Secretary to the Government of Assam. For all the above reasons, I find Exhibit P12, order passed by the respondent number 1, cannot stand the scrutiny of law. The Exhibit P12 is therefore set aside. There will be a consequential direction to the respondent to extend the petitioner's medical benefit on par with the benefits available to the all India citizens. Therefore, my lord, whatever this section has said, my lord, 16.5, the benefits of the chief secretary has to be provided to the state chief information commissioner, and the chief information commissioner will get the benefit of the election commission. And the benefit to the state chief election commissioner has already been given, as I have already pointed out. Now they are saying the same benefit cannot be given to the petitioner because that he is not an IAS officer or not a chief secretary. That doesn't, it is completely, my lord, and without any application of mine and his argument. So therefore, my humble submission for the court that petitioner is entitled to all the benefits under section 16.5, particularly taking into consideration last proviso of section 16.5, which says, my lord, even after appointment, the benefit continues. So three benefits, my lord. One is gratuity, and the other is about additional pension, and that post for peon for the lump sum, my lord, peon for the telephone operator, which the chief secretary. And
Yes,
the judgment, that the division bench judgment, my lord, which your lordship has said, that's a different, completely on different. Last occasion also when I read it is completely on different platform.
This is on parity of pension.
Yes, completely different platform, because now there, my lord, state information commissioner was seeking the benefit of the state chief information. So that's a totally different.
Yes. Yes, respondent.
But I will wait for some time to, I could not lay my hands on this. For 1 or 2 days then I'll prepare it.
All right, we have it on 13th. 13th of
Lordship has heard this matter, my lord. Here, government has also submitted only on that additional pension. Your lordship wanted the.
Heard, Mr. P.T. Das, senior accountant, listed by Mr. H.
Harder.
HR. And Mr. D.J. Talukdar, and senior counsel, assisted by Ms. M. Gorman. Anyone else? Mr. Or Pujari or respondent?
Respondent number 5, finance.
Respondent 5, finance department. Respondent 4 on behalf of? Not respondent 4. Yes, respondent 3. Architect. The learned senior counsel has argued the matter. And
I'm concluding.
Concluded his argument. The counsel for the respondents crave leave of the court to give their reply on another date. Accordingly, as agreed to, let the matter be listed on 13th as a part-heard matter, and attempt will be made to dispose of the matter on that date, 13th. Itu
My lord, I have informed the other side. They will be able to appear after 2:30 only.
We can't fix it. We'll call it at the end of the list. Please ask them. End of the list. End of the list today.
Items 30 and 31.
None appeared for the petition. Pass over. Yes, Mr. Wood.
They are yet to file the affidavit, method.
I'm very
But in terms of the earlier, interim order has been.
You're appearing for?
For now, 5 minutes.
5.
Sometime we required to file affidavit matter.
Lordship, I'm appearing on behalf of Corporation Department. We have received the instructions, Lordship. Finally, 2 weeks time may be allowed to file.
Counsel for the respondents submit their instructions are complete. They pray leave. They pray for some time to file their counter affidavit. Are you filing any affidavit?
We will be filing, my lord.
Had to be listed after 3 weeks. Any interim order?
Interim order is there, that may continue.
Interim order passed earlier. Will continue.
Highly honored.
Item 33.
Wait, please. On this matter, the private respondents have not filed their affidavit. Matter under the SARFAESI Act, for physical position. In this case, what has happened is that the physical position was taken, my lord, under the guidance of the magistrate concerned. Thereafter, after a period of 1 month, the security guards were attacked, my lord, by the private respondents. FIR has been filed. This is way back into 2022. The office of the district commissioner is slightly reluctant, my lord, to go for this thing again. That is the only issue. If your lordship will kindly come, my lord, to the FIR that we have filed, my lord, which was also registered. That is at page 73. Annexure 11. We have given the details of the entire incident, my lord, and this was registered, my lord, lordships will find under sections 120B, 448, 188 IPC. This was on 1/10/2022. my lord. So the possession that was taken by the magistrate on 30th of August, my lord, that.
Yes.
Your Lordship, I'm for respondent number 4, the private respondent. Your Lordship, as per the instructions received by me, my contention is that present the property which the bank is claiming to take possession, that is a different property than the one which had mortgaged.
Have you filed your response?
I have not filed.
Then what is your stand? You have to reflect.
We will do that.
Your instructions, you can't keep it close to your heart. You have to file it, bring it on record. Then who's for the state?
My lord, implements are already, it's a compliance of section 14 has already been done, my lord. Due to that forceful occupation of the private.
You file your response. Why don't you file your response? Is it filed?
No.
No, response is not filed, my
Then
lord.
file it.
But limited issue is to hand over, my lord, that already that has been provided, that due to their possession, my lord. I have to take instruction regarding that FIR is filed, my lord. One police case is also registered.
You are to hand over possession of which property?
That instruction I have.
No, the property is
Otherwise-
mentioned in the writ petition, and the property was already taken possession, handed over by the magistrate. And
Yes,
after a 1 month, my lord, they my lord, entered forcefully, overpowered the security guards, my lord, and my lord, took over possession.
So what is the
The only remedy is through the magistrate, my lord, because we also cannot enter, my lord, forcefully. So the only remedy is now that the magistrate, my lord, has to be appointed again. Because, you know, they are in illegal position. They
where
are-
is the order? Where is the order of the magistrate?
my lord, the previous order of the magistrate is there, my lord. That is that page 17. This is 25 August 2022. The
Page
property,
number?
70, annexion 9. Pursuant to this, my lord, lordships will find, my lord, page 71. This is the Panchnama and inventory, my lord, which was prepared in the presence of the magistrate. And the possession was taken over by the magistrate, handed over to us. We appointed security agency, my lord.
they overpowered them, my lord, and forcefully entered. They in fact, my lords, have created a chaos. My lord. They're illegal. They're now trespassing in that.
But why should the magistrate keep on handing over possession to you? You have already been handed over. You are unable to retain it.
That is, my lord, there.
Go and approach the proper forum.
My lord, there is no other remedy in law. My lord. Section 14 is the only remedy, and the specific, my lord, this is a prima facie an offence under 188 IPC also. Because
Then you have your remedies elsewhere. Why have you come before the court?
my lord, the only way that we can take possession is through the magistrate. My lord. Section 14.
You have already been handed over possession.
No, that is there. But my lord, the sanctity, my lord,
It is
of that
not
order.
there. Look out to
No,
ensure that
we are not blaming them.
maintain
They are
the-
not. No. They are not. At
maintain the
fault.
possession of the land which is handed over to you.
That is correct, my lord. That is there. They are not at fault here.
Then why should there be a direction? Under what provision?
No, under section 14 only. my lord.
Why?
Because, my lord,
That has already been handed over.
my lord, there can be a fresh order also.
Why?
Because, my lord,
Where is the guarantee that you will be able to look after the property after it is handed over?
my lord, the issue here is that, my lord, these people, my lord, they violated the orders of the.
You have an issue with these people, you take it out. We are not stopping you from doing it. We are only asking you that you have come before a court for a direction to the magistrate to hand over property.
Yes.
The property which has already been handed over to you.
Yes, that is done.
Then?
No, section 14, that is there. But since, my lord, physical possession, my lord, neither we can enter forcefully.
We don't
nor, my
know.
lord, the civil court has any. There is no other remedy in law, my lord.
There is no other remedy. I don't agree to your submission that there is no other remedy.
No, in this case, my lord, the sanctity,
It
my
is
lord,
not
of the
for us
order.
to give you legal advice, but we
No,
disagree with your submissions that there is no other remedy.
There, my lords, we can only go through section 14 only. my lord,
Your
Because here, my
14
lord,
has been complied with.
we have made a fresh application. We have made a fresh application to the magistrate, my lords, that we have annexed also.
Show us 14.
Yes.
Sir, please.
Lordship, sir.
Yes.
If I may read them. Where the possession of any secured asset is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under the provisions of this act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the chief metropolitan magistrate or the district magistrate within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the chief metropolitan magistrate, or as the case may be, the district magistrate shall, on such request being made to him, A, take possession of such asset and documents relating thereto, and B, forward such assets and documents to the secured creditor, provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor, declaring that, so 1 to 9, all these details are given as to what should be the contents of that application. And the proviso, down below, provided further that on receipt of the affidavit of the authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured assets within a period of 30 days from the date of application. Provided also that if no order is passed by the chief metropolitan magistrate or district magistrate within the said period of 30 days for reasons beyond his control, he may, after recording reasons in writing for the same, pass the order within such further period but not exceeding in aggregate 60 days. Provide also that the requirement of filing affidavits stated in the first proviso shall not apply for proceeding pending before any district magistrate or the chief metropolitan magistrate, as the case may be on the date of commencement of this act. The district magistrate or the chief metropolitan magistrate may authorize any officer subordinate to him to take possession of such assets and documents relating thereto, and to forward such assets and documents to the secured creditor. 2. For the purpose of securing compliance with the provisions of subsection 1, the chief metropolitan magistrate or the district magistrate may take or cause to be taken such steps and use or cause to be used such force as in his opinion may be necessary. No act of the district magistrate or any officer authorized by the district magistrate done in pursuance of this section shall be called in question in any court or before any authority. No, there is nothing regarding any bar to a subsequent application.
No, but there is no provision that you can file an application.
That is there, my lord, but the fact that, my lord,
There are other remedies, you take recourse to other remedies.
my lord, they approached
Beyond
me,
this act, there are other remedies available for you.
those remedies, my lord, in this case, my lord, they will not, because the section 14 will come as a bar, my lord, because
Why section 14?
because the only way that I can take physical possession is
Which have been given to you.
Yes, it has
It's not a case that possession has not been handed over to you. It's a
Lord.
case that possession after being handed over to you, you were unable to retain it. There's a
Lord.
difference,
that is due to the act of the private respondent.
whatever it may be. But it is not a case that possession was never handed over to you.
That is correct, my lord. But here, my lord, this is a case of an order. The magistrate took the
14 is
possession.
with regard to handing over possession,
Yes,
which has been done. Now, what you do after the possession being handed over is not
that is there, my lord. But there
defined
is,
under 14.
but there is no bar to a subsequent application, my lord, because my
There
lord,
is no bar, means there is no express provision
Lordship.
saying that such a, as and when required, you can file applications under 14 or any other provision of law.
My lord, here is a case, my lord, with, my lord, the rule of law has to be upheld, my lord. This is in this case, if the,
Law has to be upheld provided you are vigilant.
Lord, we were
provided-
vigilant, my lord. We
provided-
appointed security agencies, my lord. Had it been a vacant property, it's something.
But you have not been able to retain it. There are
Lordship.
provisions available for you. You go and file a suit.
Lordship will kindly consider, my lord. We appointed a security agency, my lord. There were security guards who were there. They were overpowered. Because as far as we are concerned, my lord, we did our utmost, my lord, because my lord, when they come with a mob or a my lord, gundas, my lord, we cannot resist.
You are the bank, isn't it?
Lordship.
As a bank, are you telling us that you are helpless on the given date of the incident? You could not approach the district authorities. When did you file complaints before the authorities concerned?
Yes, my lord. My lord, first we went to the, my lord, police on 1st of October.
When, according to you, the possession was, you were dispossessed?
Lordship, that date is
When was it handed over to you?
that was the handing over, my lords, took place on, my lords, 30th of August 2022, my lords.
22.
Yes.
Then, when did
And
you
my
file
lord,
your application?
on 1/10/2022, my lord, they dispossessed. They forcefully entered the premises and threw out the security guards who were there.
Then?
And then, my lords, on 1/10 only, we filed the FIR also. And subsequently, my lords, on 22/12, lordship will find at page 75, we approached the district authorities again. That is at page 75, 22nd of December. Because when the police, my lord, did not take any further action thereafter.
If the police doesn't take further action, you have remedies under the criminal procedure.
That is there, my lord. But the police, my lord, cannot evict them also from the premises. That will be a difficulty because the police can only file a challan in the court, my lord, and they cannot be evicted by the police. The only method of evicting them in this case would be, my lord, via the magistrate. And my
You are
lord,
not convinced. Yes.
Yes, my lord, that compliance of 14 has already been done. At best, I can have the instruction regarding that registration, after registration, whether any action has been taken or not. But so far as title and enforceable right is concerned, my lord, for that remedy lies in the civil court, my lord. Either of the party, police, how can police decide their
police cannot decide the issue of title.
Title,
And they
my lord.
approached the Debts Recovery Tribunal on 2 occasions. Their cases has been, their essays have been dismissed, my lord. They have no other remedy. That is why they forcefully entered the premises. That is why they are not filing any affidavit. My lord. File it and admit. My lord, if they admit that they are in possession, it's a violation, my lord. Prima facie, my lord.
Submitted lordship, already a suit has been filed regarding that. And there is
Who filed a suit?
we have filed a suit
For?
because the property is different. We have, and the concerned court has appointed a local commissioner also, and the report is awaited. The report has to be submitted in the next date is on 21st of June of the same this month.
Is when the section 14 proceeding is there, my lord, there is no injunction in their favor. They may file a suit.
You're a party in the suit.
No, yes, my lord. We have filed party that there is no order of injunction, my lord. And section 14, my lord, the apex court is absolutely clear, my lord, that they have no locus standi to say anything. It's not an adjudicatory process. If they had an injunction order in their favor, my lord, very well. That's a different aspect of the matter. But the suit is filed in 2022.
No,
we are in
but-
24.
but technically, can you say that section 14 was not implemented?
No, we are not saying for a minute that.
You are asking for a,
Redoing the process.
another action or an order to be taken under section 14.
Yes, my lord, because in this case, my lord, we were not dispossessed after taking the possession. This was not a case of voluntary surrender, my lord. This was a case where the magistrate took possession, my lord, after evicting them and handed over the possession to us. We are not blaming the district administration
So
for a unit.
the possession was under you. When according to
Yes.
you, they had dispossessed you and
Yes.
taken over the land.
After the magistrate handed over possession. So this was a case, my lord, where a direct official order has been violated. Now the police will not be able to evict them, my lord. So the only remedy, my lord, here is a case, perhaps the rule of law has to be upheld, my lord, by, because otherwise it will.
I can't agree with you, your submissions. You have to make out a better case. We are giving them some time to obtain the instructions.
Good.
You find out what is the status.
Fine.
And you are at liberty, private respondent, to file your affidavit if you want. Matter be listed after 3 days, enabling the government advocate to obtain instructions as to the status of complaints filed by the petitioner that the after the possession of the land in question has been handed over to the petitioner by the magistrate in terms of section 14 of the SARFAESI Act. The same was the petitioner was dispossessed by the private respondent and the land is presently under the occupation of the private respondent. Violation of the orders passed by the district magistrate. Let the matter be listed after 3 weeks.
Let a date be
26th June.
published.
Let's say, fiction under section 11(6), my lord, appointment of arbitrator, my lord. There is a admittedly, my lord, there is a dispute, my lord. My lord, they have filed an affidavit, partially, my lord, is there. And arbitration clause is there, my lord, that your losses.
What is their stand in the affidavit?
Notice has been sent, my lord.
What is that?
Oh, stand, my lord, they have taken, they have said that some amount has been paid, some they have deducted due to some defective of the drugs and other things, my lord. They have, at page 116, my lord, they have said. So that is a dispute, my lord, that.
No, but why have they not appointed? You have yet called upon them to appoint an arbitrator.
Yes.
Yes.
Appointed, my lord.
Your lordship may kindly see the arbitration clause, my lord, at page 33. Any dispute, 27 point, my lord, any dispute whatsoever in any way arising out of or relating to the contract shall be referred to arbitration of the Mission Director, National Health Mission, Assam, or to the sole arbitration of the same person nominated by him. There shall be no objection if the arbitrator so appointed happens to be an employee of National Health Mission, Assam.
This is, my lord, prior to 2015 amendment. After 15 amendment, my lord, it cannot be done, my lord, now. Now independent arbitration. They cannot be, my lord. Even the arbitrator who is not qualified to be arbitrator, he cannot also appoint arbitrator. Now that is the law. Section 12(5), my lord.
Yes, madam.
Section 12(5), my lord, now qualification is provided in section schedule 7. Now it cannot be done.
That agreement was taken place, my lord,
Huh?
between their parties,
When
my
was
lord.
the agreement entered?
And then-
Earlier, my lord, prior to that.
Oh.
Fourteen. 12, 11, 14, my lord. Tender. That is the tender clause, my lord. 12, 11, 14.
No. Thank you.
12.5, my lord. Section 12.5.
Even you said you.
In railway matter has been referred to larger bench, my lord, because there is a clause that they will refer, that will refer. Hmm? Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or council or subject matter of the dispute falls under any of the categories specified in 7th schedule shall be ineligible to be appointed as arbitrator, provided that parties may subsequent to a dispute having arisen between them waive the applicability of this subsection by express agreement in writing. So, in the arbitrator is to be appointed, my lord, by a law. They cannot be.
Yes. We await the judgment of the larger bench or what?
No, not this. Here not required, my lord.
Not required.
Here not required. That was a disputed matter, my lord. Here, law is absolutely clear. And Lombard judgment has, my lord, this that is judgment has quoted. If your lordship see, my lord, paragraph 25 onwards. Your lordship may think. Very interesting, my lord.
25.
25 onwards, my lord. 26 may be seen, my lord. Taking cognizance of the legislative change, this court, my lord, after that Bureau so and so, noted that post 235 amendment, the jurisdictional court under section 11(6) of 1996 Act is limited to examining whether there is an arbitration agreement exists between the parties. Nothing more, nothing less. This is the, my lord, law actually.
Where is your demand for appointment?
Yes,
Yeah.
that's my lord, page 97, my lord. Next,
Yes.
Provided.
A retired judge may be appointed, my lord, of the High Court.
The arbitration.
Your lordship can appoint any part, Malad, not the least we are here to. Yeah.
Yes, Madam. Yes, what?
Your Lord, may be appointed.
May be appointed. So you are agreeing that this is the dispute is referable to arbitration.
In in my affidavit, my lord.
In your affidavit, you are saying that there is no dispute.
Yes, my lord. As the minutes of the meeting has been annexed, my lord, in my annexure A, my lord, page number 119, my lord. Where their senior executive officer was present, my lord, and they agreed to accept that amount, my lord. At paragraph 8, I have stated all these things, my lord.
No, but where is the agreement recorded? Huh?
No agreement recorded.
There's no agreement recorded in the minute.
No.
You have decided that this is the amount
Yes.
to be paid.
Yes. I have decided.
When do you say there is an agreement?
No.
In the meeting where he was present and
You
agreed.
may have been present, but you can't say there is an agreement.
No, madam.
It is not recorded that he has agreed to this, to receive this amount. I cannot. We'll just take out that notification. There is a notification.
Well,
we will, you share it and you tell us who is to be appointed.
I had no choice, my lord, actually. One, my lord. Because even without notification also, my lord, your
We can do, but there is a notification.
Yes, that can be.
You can have a look.
Huh? Look, the two names of the hypothesis, they cannot take it up. Yeah, the district and session judge may.
District and session judge.
Their names are there, my lord. Or any other high court judge, my lord. Justice P.K. Musari or H.K. Sharma, anybody, my lord.
All right.
Any other person may be.
Mr. Ian Sahiwala, Senior Counsel, assisted by Mr. M. Sahiwala, Counsel. MS Bora, A. Bora, Standing Counsel. What is that? NHM. Hearing for the respondents. So, this petition is filed under section 11(6) of the arbitration 1996. So there are the petitioner and the respondents that executed, entered and executed an agreement for supply of drugs pursuant to the tender notice number so and so dated 11/11/2014, page 617. So the said tender was awarded to the writ petition to the petitioner at his quoted price. Stop. The learned counsel for the petitioner submits that during the course of the execution of the tender, certain disputes arose between the petitioner and the respondent in respect of the price for the amount to be paid by the employer, by the respondent authority. So, in spite of repeated requests to resolve this, repeated attempts to resolve these disputes mutually, the same could not be resolved, and ultimately, meeting was held between the petitioner and the respondents, and on 5/2/2020, the respondent authorities held that the total amount payable to the petitioner would be 2,29,15,123. So this is reflected in the minutes of the meeting held between the petitioner and the respondent NHM ID minutes dated 5/2/2020. So learned counsel for the petitioner submits that this amount which is being offered to the petitioner. This is the full and final payment.
My lord?
This is the full and final payment.
No, no, I object.
No. By
Yes, I am full on.
the full and final payment shown by the respondent, the minutes not acceptable as the petitioner are entitled to amount higher than the amount held. So, since the respondent did not relent to the requests made by the petitioner, notice for referring the matter to arbitration was served on the respondents by under section 21 of the Expenditure Act by notice dated 24/2/2023. So it is submitted that in terms of the provision of section 21, since the respondent did not respond to the notice issued by the writ petition, the petitioners are before this court seeking an appointment of an arbitrator under the powers exercised by the court under section 11(6) the Arbitration Conciliation Act. The counsel for the senior counsel for the petitioner submits that in terms of the agreement, arbitrator was to be appointed by the arbitration was to be referred to
Mission director.
the mission director, National Health Mission, or to the sole arbitration of some person nominated by Learned Senior Counsel submits that in view of the amendment carried on to the Act of 1996, section 12(5), the mission director. He is an authority who is covered under Schedule 7 of the Act and is therefore barred from acting as an arbitrator or even nominating an arbitrator under the provisions, amended provisions of Section 12(5). He refers to the judgment of the apex court in Perkins.
My lord.
In Perkins, and so reported it to it. So he therefore submits that having no alternative, his application under Section 7(6) has been filed, seeking an appointment of an arbitrator by this court. Where, MS Bora, standing counsel in NHL, has referred to the counter affidavit filed by the petitioner. Filed by the, according to the respondents, there is no dispute, and the terms of the minutes recorded on so and so date, the petitioner has agreed to the amount calculated by, mutually calculated by both parties, and therefore there is no dispute. So, that apart, he submits that as per the arbitration clause, it is to be referred to the. Do you make this submission? No. Are you submitting that arbitration should be referred to the mission director in terms of 27? It's that. In terms of the agreement executed by and between the parties under clause 27, arbitration is to be referred to the mission director, NHM, or the sole arbitration of some person nominated by him. Better. Counsel, the parties have been heard. Readings available on record and provisions of the Arbitration Conciliation Act, particularly Section 12(5). It's taken note of. 12(5). Right is under Section 12(5). So, the arbitration clause as available in the arbitration agreement is also expected, and the same provides same provides for arbitration as under page 51, clause 27. So, pursuant to the amendments brought in Section 12, incorporating Section 12(5, with effect from 23/10/2015, it is abundantly clear that notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or the counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. So, in terms of the agreement that are executed by and between the parties, arbitration is to be referred to the mission director, national health mission, or the sole arbitration of some other person referred to or nominated by the mission director. So, the agreement also reveals that the where is there an agreement somewhere?
Arbitration clause?
No, agreement.
No, my lord. No other agreement, my lord. This is all the terms. The order is at page 52.
Is mission director referred to somewhere?
Mission Director.
From from an examination of the things available on the report, you see that the uh, tender on behalf of tender for supply of drugs on behalf of NHM is called for by the Mission Director of National Health Mission. Stop. The position held by Mission Director is not specifically provided for in the agreement, but from the arguments made before the court and from a careful perusal of the pleading, it is apparent that the Mission Director is an authority of the management who has the controlling influence over the organization with with whom the petitioner has entered into the agreement for supply of drugs in terms of the so and so agreement. That being so, as per the prescription of the 7th schedule, arbitration is prohibited to be conducted by, or even a reference is prohibited to be made by a person who is a manager, or a director, or a part of the management, or a similar controlling. Stop. This aspect has been elaborately dealt with by the apex court in the judgment referred to in Perkins versus so and so Supra. Stop. Under such circumstances, it is evident that the mission director is precluded under section 12(5) read with schedule 7 of the Arbitration and Conciliation Act to act as an arbitrator of any dispute that has arisen between the petitioner and the respondent, or even to refer arbitration to any other person or as an arbitrator. Stop. Under such circumstances, as had been held by the apex court, it is the court under section 11(6) that an arbitrator has to be appointed. In such view of the finding arrived at by this court, this court is of the view that since the disputes stated to be there between the parties have not been shown to have been resolved mutually in the meantime, and there is no material available on record which has been pointed out to the court to show that the amount stated to be payable by the respondent to the petitioner has been accepted without any demand. I, as a court, powers conferred under section 56, appoint H.K. Sharma. Justice H.K. Sharma, retired, to act as the sole arbitrator, to decide to enter into an arbitration to decide the disputes arising out of by and between the parties out of the agreement number so and so, dated so and so, executed by and between the parties. So the appointment, however, is subject to the consent to be given by the learned arbitrator and subject to fulfillment of all the terms and conditions by both parties. So the arbitrator will also decide the arbitrability of the dispute if the need so arises.
Well, the Parkins case reference was 2020, 20 SCC 760.
2020,
Seven-
2020,
2020, 20 SCC
volume 20.
volume 20,
Okay, 2020.
760. It is apart to in this Lombard
760.
case also, my lord.
Yes.
Lombard case. At page six.
Lombard, as also
Yes.
Lombardi Engineering
Yes.
reported in 2024 4 SCC 341.
Mal.
Arbitration petition is accordingly disposed in terms of the order.
Item 33.
My lord, this was the appointment of arbitrator, but in terms of the office note dated 28/5/2024, steps has been taken, but the respondent 3 and 4 has, my lord, his AD card has not returned. So await service report is there, my lord.
3 and 4. Anyone appearing for 3 and 4?
No, my lord.
You are appearing for
1 and 2, my lord.
1 and 2. So we'll have to await 3 and 4. 3 and 4, Mr. Goswami.
We have taken steps, but nobody has appeared. So we'll have to wait.
As per office note dated
28/5.
28/5. Service is awaited on respondent 3 and 4. So we await service report. And Mr.
N. Chaudhary.
Chaudhary N.
Chaudhary.
N. Chaudhary appears on behalf of
1 and 2, my lord.
respondents 1 and 2. What about 5, 6? Yes.
My friend appears to 5.
I'm appearing for 5, 6.
Mr.
Ardas.
Mr. Ardas appears for respondents 5, 6 and 7.
7.
Yes, ma'am.
Already.
Matter be listed after 2 weeks.
Yes.
With the required office note.
Obliged.
Deeply obliged.
Meanwhile, respondents are permitted to file their response with 2 advice in the meantime.
Obliged.
Item 37.
Please, your lordship. Please, your lordship. Affidavit in reply will be filed. So we are sending it to for vetting, and the petitioner is residing at Gurugram. So some time may be granted.
Counsel for the petitioner prays for further time to file the reply affidavits to the affidavit filed, rejoinder affidavit to be filed in response to the affidavit in opposition filed by the respondents. He prays for 2 weeks time. 2 weeks time. Mr. Odhikari appears for the respondent.
SRA Nasser for the respondent.
List after 2 weeks.
38 the same.
38 same. Okay. 37, 38.
Highly obliged.
39.
Yes.
Time they were granted time to file the affidavit, my lord. After that, my lord, there is one more development, my lord. In this impugn order, my lord, there were 2 companies in JV, my lord. One is before my lord, and other company has also filed a writ petition which was listed today before court number 4, my lord. And that order has been reserved after argument, my lord.
Oh.
So, my lord,
Come up after 2 weeks, my lord. In the meantime, my lord,
but same order is to be passed, my lord, because it is allowed, my lord, but it is not dictated in open court. Most of the thing was dictated, my lord, but only the operative part was remaining. By that time, lunch break happened, my lord. So my lord told that we'll pass order in the chamber. So order has been reserved.
All right, you place it before the court.
I will place it, my lord, within 2 weeks.
Mr. Soikia, you are appearing for
I'm appealing for NHRECL, my lord.
NHIDC.
2, respondent number 2 and 3. One is Union of India.
I heard counsel for the parties. Mr. P.J. Soikia, senior counsel, assisted by MS
M. Tirola.
M. Nirola, appears for the respondents. NHIDC. It is submitted at the bar that petition before the petition filed by
one of the other JV partner, my lord. One partner is before
one
my
of
lord.
the JV partners of the present writ petition.
Feedback Infra.
Namely,
Feedback Infra Private Limited.
feedback within quotes feedback infra private limited. and also filed a writ petition. This matter has been heard and disposed of. However, the order is not available with the council. Accordingly, the councils submit that the matter be listed after 2 weeks, by which date the order, if available, will be placed before the court.
9
Prayer made is allowed, matter be listed on
19th, my lord, or 21st.
19th. All right, 19th.
Deeply well.
19th.
Supplementary list for admission, I think.
Lordship will find the impugned demand show cause notice in page 190.
Interim to continue with it.
Interim orders will be till the next 6 weeks. Yes.
You have given the letter, paragraph 2 and 4 may be pending.
Have you served a copy on it? Are you
No, Lordship.
2 and 4? Some SLP is filed. You show it to him.
We are not proceeding with the impugned notice.
No, but till the SLP is disposed of.
That already is already.
Lordship, the crux of the matter is that, Lordship.
Let him argue then. Lord.
No. You are saying that you are not, it's not clear.
No, Lordship.
Are you dropping the matter
Yes, Lordship.
completely, or it is still the disposal of the SLP?
Lordship, earlier order is there. Thereafter, this notice was issued a protective demand. It's the inspection of the department. Now, Lordship, when I sought opinion, I said that already their demand is already protected. So there is no need to proceed with this notice. So paragraph 2 is, last 2 lines are very clear.
No, that's what, till the outcome of SLP.
Yes, sir.
Lordship, in fact, there was.
So if it is still the outcome of SLP, then the writ petition can't be disposed of.
We kept one or it may be disposed of in view of the center.
Because if you start proceeding, then we'll have to give them liberty to come again.
Yes, Lordship, they may come.
Yes, you go through this.
Lordship, just one submission. Lordship, there was a direction by this honorable court to pay us the interest, and that will be subject to outcome of the SLP. So, Lordship, this notice is saying that it's an erroneous refund, but it's not an erroneous refund, Lordship. It has been made, the refund was made, the interest was paid to us pursuant to directions of this honorable court. Lordship, you kindly come to page number.
Why don't you go through this communication?
Lordship. Lordship, if they are not willing to press the matter till the matter is decided by the Honorable Supreme Court, Lordship, I don't have a problem with that.
So we are closing it.
Yes, Lordship, because undertaking was already given to us.
Heard, learned counsel for the party. You give us that copy of the order. In terms of the liberty granted by the court earlier, learned counsel hearing for the GST, CGST, the KL has produced a copy of the communication dated 10/5/2024. Copy of the legal instruction. The department has decided not to proceed, not to pursue the protective demand notice. And no action is to be taken with the outcome of an SLP number filed by the department and pending before the view of the statement made by the Durham County for the respondent and the same not being completed too by the council for the petitioner, and in order to send one.
So letter may be kept as a part of the record.
The communication submitted to the court is kept as a part of the report.
Obliged, Lordship.
For others, I think 40.
May it please your lordship. Lordship, as per office note dated 24/5/24, it is reflected that the AD card upon respondent number 123 has been returned back and notices has been served. But till date, no one has appeared by filing any wakalatnam.
As per office note dated 24/5/2024, service on respondent 1, 2, and 3 are shown to be complete. Accordingly, the matter be listed for admission.
Date may be fixed, lordship.
In July,
Any date.
19 July.
Obliged, lordship.
41.
Order has been complied with, sir. To bring on record, I will file affidavit matter, ready for swearing.
You want to file an affidavit?
Yes, Your Lord.
Learned counsel appearing for the respondent submit that the order has been complied. And she would like to file an affidavit to bring the same on record. Prayer allowed, matter be listed after
1 is your, 1
after 1.
is your.
42.
Right. Non-compliance of the order, my lord, started from page 11, my lord.
Affidavit
Please compliant, my lord. You have,
complied.
You release the budget allotment of 2 lakhs, my lord, to the NOK, my lord. Late upon the account. Lordship, kindly.
Learned counsel appearing for the revenue department submits that the directions contained in the order dated
My lord, my lord, the petitioner
21/11/2022 passed by in WPC 7395 of 2022 has been complied with. Pursuant to the inquiry has been conducted. The
my lord,
yes,
as per my instruction, my lord, not yet received any money by the petitioner.
we know you have not received.
Yes, sir.
We are recording it.
Yes.
The
That part I.
the amount of rupees 2 lakh has been found to be payable to the petitioner as compensation for the death of the son of the petitioner.
No, my lord, I am the wife of the deceased, my lord, but the sanction is granted to the father, my lord.
Oh.
And the fact is, my lord,
The list of
after-
NOK, my lord, the name of the father is there, my lord.
after death, my
The
lord,
writ petition is filed by somebody else. How can you give it to?
yes,
As per extension order of the deputy commissioner, we have allowed that budget allotment, my lord.
Do they not go through the orders of the court?
It's the deputy commissioner, my lord. Sanction order sent by deputy commissioner, my lord. Inquiry done by the deputy commissioner, my lord.
and after death of husband, my lord, the petitioner and the son and daughter are driven out from the husband house, my lord.
Who is the deputy commissioner?
Respond number 2, my lord.
But the respondent number two has not appeared, my lord, but the respondent number two has forwarded a letter, my lord, class A, my lord.
This is not compliant.
My lord, as
Who's
per
for respondent
sanction
two?
order of the deputy commissioner, we had allotted the budget, my lord. As per deputy commissioner.
No, whatever you have done,
This is the
you have done it pursuant to the orders of the court.
Yes, my lord.
So are your officers not required to go through the orders of the court? The petition is filed by a person, you have sanctioned and released it in somebody else's name because the next of kin says so.
Understand, my
Whether
lord.
whether next of kin that is to be released or not, somebody has to take responsibility. The direction is to the respondents to make a verification and release the amount.
In the name of the, in the certificate of NOK, my lord, the father name is there, my lord, that's why I have to tell you.
Other name is there, but is it a find? There is no finding that the wife's name is not here.
Wife's name also there, my lord, phase 17, my lord. Serial number 4, Dalimi Deka, wife.
No, no, you file affidavit, this will not do. Yes, deputy commissioner who is appearing for DC. DC.
My lord.
Yes, Mr. Hendick. You get instructions, what have they done? You come to page number 11. Page 11. Page 11 is the order of the court.
Lordship.
It is filed by Dalimi Deka.
Lordship.
Order passed on 21/11.
Lord.
Now come to page 13, para 5. Sorry, 14, para 6. DC is directed to cause an inquiry.
Lordship.
Resulting into the death of so-and-so. And lastly, if he comes to the finding, petitioner's case falls within so-and-so, ex gratia to be granted.
It is true.
Now, in this sanction order, there is no reference of the court order or why this amount has been granted or was it proceeded independently. This, kindly go through this order.
Yeah.
It was passed by the DC.
Amount has been sanctioned to the fathers of the.
By the DC. By the DC.
No.
In view of this order.
In the order, Lordship.
DC is there as a
There.
party respondent.
This is their Lordship, the petitioner and.
Direction is specifically to the deputy commissioner, para 6.
Lordship. Let me take instruction from the. Why it is that whether this amount has been sanctioned, it is already been sanctioned to the fathers of the.
But how?
To the wife.
Please take instructions immediately. Third learned counsel for the parties, MSPR Monto learned counsel appearing for the respondent number 1 has placed before the court a communication to show that the amount of rupees 2 lakhs in the case of in respect of the death of the husband of the petitioner has been sanctioned. Stop. However, upon careful perusal, it is seen that the amount has been sanctioned in the name of the father. So, the father was not the writ petitioner before this court in WPC number so and so. 7395/2022. By order dated 21/11/2022, this coordinate bench of this court. By order dated so and so in WPC 7395 of 2022, coordinate bench of this court had issued specific directions as under Code Para 6. So, under such circumstances, the respondent number 2 is directed to explain why is permitted to permitted to file their response as to why proceedings under the Contempt of Courts Act 1971 read with the Contempt of Courts rules framed under the Guwahati High Court rules should not be proceeded with. So let the matter be listed again after 2 weeks, not 2 weeks, 1 week. 1 week, you get instructions, what has happened. This appears to be a blatant, I will not use the word disregard, but not taking into account the order of the court. List accordingly, let the matter be listed on 14th of June. Mr. J. Hendick, learned government advocate, is requested to enter appearance on behalf of the respondent number 2 and obtain the required instructions and place it before the court by the next date fixed. Copy of this order be marked to the office of Mr. J. Hendick for onward communication. And you give a copy of this instruction, we'll retain in the file. You give it to the Mr. Hendick also. Get the instructions ready. Yeah.
Service has been completed upon the respondent matter. The last occasion, madam, number 2 and 3 short time for getting instructions. I'm against freezing of my salary account.
Yes.
Your Lordship, that page number 30. That is the complaint they have filed before the ombudsman. That is the respondent number 1. And the case is that Mr. Alahuddin has availed a loan facility in which the writ petitioner is a guarantor, and his liability is coextensive with that of the main borrower, Your Lordship. So we have put an lien in reference to section 171 of the contract. And section 128 says that the guarantor.
You are the
liability is
guarantor.
Yes, I was guarantor.
You will be
But
placed.
my lord, kindly see, there is I am a grade 4 employee of a school, my lord, and he was a teacher, my lord. And kindly come to page number 23, my lord. He has served as a teacher for 25 years, my lord. And thereafter, an FIR was lodged by the respondent number 4, my lord, against him, that he was found, his document was not found genuine, my lord. Accordingly, he was dismissed from the service, my lord.
Wait, you are a guarantor.
Yes, my lord.
You look
Because
into the
under
provisions of
impression-
the act,
Yes,
your
yes.
guarantor, you are on the same footing
Yes,
almost
yes, my lord.
as that of the borrower.
But my consent, when it was taken by Alauddin, my lord.
You have a claim against Alauddin, you go and file against him.
No, my lord, kindly and kindly come to page number 28, my lord. Not only me, my lord. The department has also.
Whatever it may be, is there a finding that these documents are forged then on the date when you stood as a guarantor? Yeah, you are not aware that these documents have been forged or false document?
My lord, because I don't have any knowledge that he is not having any genuine.
That's right.
Apart from that, my
But
lord,
there
no
has to
notice
be
has been
there has
served
to be a
upon-
finding.
Yes, my lord.
That's the whole purpose of a guarantor, that in case the borrower failed, you stand in guarantee. Now, if you did not understand the true purport of a guarantor, then ignorance can be held to be bliss.
But my lord, kindly see, my consent was, as a guarantor, was taken under misconception. My lord. And kindly come to page.
Then you file, then you have a remedy before the court.
Civil court.
You file you take your recourse to the remedy available under law. Merely because you were not aware on a statement made is not sufficient to absolve you of your responsibility.
My lord.
There must be a finding.
Yes, my lord, but whether any proceeding against the principal borrower, my lord, has been initiated, my lord, because, my lord,
That is not even a concern.
my lord,
It may be initiated, may not be initiated. Therefore, you are a guarantee. It need not be initiated against him. That's the mandate
but
of
my
the-
lord, kindly see, my survival is on the risk. my
That's
lord.
what I said.
Yes, ma'am.
Ignorance is not bliss,
Yes.
always.
Because I am not saying that I will not pay, my lord, but some portion has to be given for my
You
survival.
file an application before the authority, let them agree whatever amount you want to pay, you pay and sort it out.
My lord,
We are not here to negotiate on your behalf.
okay, my lord, then, my lord, 2 weeks time maybe.
All right. Counsel for the petitioner, prays for 2 weeks further time. To complete his instructions. Mr. M. Sharma, appears for the bank. Are you appearing for someone?
No,
I'm
he is-
appearing for education department. Respondent number
For education. MS?
B Tech.
B Tech. P or B?
B.
B Tech. Appears for education department. Yes, you have obtained your instruction.
All right.
44.
Your lordship, notices has been served, but no one appeared till date.
Who has not appeared?
5 and 6.
Who are 5 and 6?
Municipal board roads.
You take steps through respondent number 2. Heard learned counsel for the parties, as per office note. In terms of the earlier order, service, trustee service, they have not accepted.
They've accepted.
They've accepted. Trustee service has been effected on respondents 5 and 6, and the respondents 5 and 6 have accepted the notices. However, they have not appeared before this court. So, let notice be taken again on respondent 5 and 6 through the office of respondent number 2, namely the Director Municipal Administration. So, the respondent number, the petitioner will serve extra copies on the office of the director, who in turn will ensure that the copies are served on the respondent 5 and 6, and an affidavit of compliance thereafter be filed by the respondent number 2, that the steps have been effected on respondent number 2, 5 and 6 pursuant to this court's order. Let the matter be listed after 4 weeks. Petitioner will furnish extra copies within 10 days before the respondent number 2 as directed, along with a certified copy of this court's order.
Item 45.
Yes.
Herein, your lordship, notice has been served, your lordship, and it should be listed as admission, I think. But
As per office note 23-1,
11/3/2024, your lordship, that order money.
7/3/2024. Office note dated 7/3/2024. Service of notice upon respondent 1 and 2 has been accepted to be complete. However, none appears for the respondent. Let the matter be listed for admission in the month of July.
If it is possible, your lordship, this month, because my construction has been stayed, your lordship. In 20, your lordship.
24th, list on 24th. June.
40. Item 46.
The service is not complete, lordship, regards to question number 5.
When your lordship now kindly see the address of the respondent number 6 lordship. Page 5 lordship. And the lordship may kindly turn to the internal page.
You take dusty service?
Lordship, yes, lordship, we attempt to lordship, serve dusty also, lordship, but lordship, the petitioner, now the respondent is not here, lordship. He has left the place.
Huh?
He has left the place, lordship. Now, lordship, in the requisition, lordship, they are given an address, lordship, we will start copying that place.
Learned counsel for the petitioner is permitted to take dusty on the respondent number 6 at the correct address.
Correct address.
Let
Dusty
the
as well as
be-
lordship.
Huh?
Dusty as well as normal, usual person.
Dusty as well as
Because dusty
steps
is
by
not
usual
receive also.
process. Let the matter be listed again after 3 weeks. So J. Antique appears for
Lordship, respondent number 1, 2, 3 and 4 lord.
our respondents 1, 2, 3, 4. List in the month of July.
Lordship.
47.
Yes.
May please, your lordship. After passing of this honorable court order in WPC numbers 1734 of 2007, we have issued notice for demolition of the illegal construction. 2 weeks time may be given to file our record.
Yes.
Nothing has been done. Since August order, my lord. Contempt petition. Can we say page 24, man? 27 is relevant.
Third, counsel for parties. Counsel for respondent, please leave to file. Complete his instructions and apprise the court as to the steps undertaken in terms of the direction contained in the order dated 11/8. Twenty 2023 passed in WPC 1734 of 2017. Let the matter be listed again after 3 weeks, 2 weeks.
Let me.
Date is on 26th June.
Well, replayable.
Let it be in July, reopening. 15 July. Yes.
Lordship 48.
Lordship, in this matter, Your Lordship, the matter relates to ex gratia for terrorist killing victim. Your Lordship. So here, Your Lordship, proposal, page 9 is the order. The Deputy Secretary to the Government of Assam Home and Political asked the Deputy Commissioner Dima Hassau to submit a fresh proposal online. So accordingly, in the next page, Your Lordship, it has been done, the sanction order has been given, Your Lordship. 3 contempt petitions together are there. Today it is 92, 2024. So they conveyed me, Your Lordship.
It has been sanctioned.
Yes, Your Lordship. 6 weeks, because some monetary issues are involved. So that's why 6 weeks they. So let it come after that, Your Lordship. Well, I shall. I'd ask them to do the needful prior to that only.
All right, let it be listed after 4 weeks.
Right.
As it is submitted by the council for the respondent that the amount required to be sanctioned.
But if the petitioner do not have problem, Your Lordship, and can it be with, by 6 weeks only, then necessary complaint, as they had conveyed me.
Not 6 weeks, 4 weeks. As to for release of the amount which has already been sanctioned, stated to have been sanctioned by the office of the Commissioner Dima Hassau Haplong by order dated 31st of May 2024. Based on so and so date. After 4 weeks. After 4 weeks, on a date to be fixed by the registry.
Right. 45.
Yes.
Lordship, I render my humble apology that I could not appear on the last day. It's a medical emergency.
Yes.
Lordship, it's a requisition filed against an ombudsman award.
So why is it for orders today?
Yes.
As per office note, service on respondent 2 is complete. Matter be listed. You are for respondent 1. Respondent 1 is also represented. Matter be listed for admission in the month of July.
Lordship, it's a date.
On a date to be fixed by the registry.
My lord, only my lord, problem is that my lord, some award has been passed by the ombudsman for a month. 2 lakh, 2 lakhs, my lord, 2 lakh something, my lord. My lord, that money has not been, my lord, my lord, may I pay, my lord, some earlier date?
No earlier date. It has to be in July. After vacation. On a date to be fixed by the registry.
Date may be.
Be fixed by the registry.
Item 50.
Yeah, as per office note dated 3/6/24, service is complete upon respondent number 6, 7, and 8.
We have not received extra copy till date, my lord.
As per office note dated 22.
3/6/24.
3/6/2024, service is complete on respondents number 6, 7, and 8. However, none has represented respondent 6, 7, 8. Matter be listed for admission in the month of July.
For the extra copy.
Council appearing for the transport.
Corporation Department.
Corporation Department. However, submits that extra copies have not been furnished by the writ petitioner. So, council for the writ petitioner undertakes to furnish sufficient extra copies on the council for the respondents Corporation Department before the next date. Well before the next date. List accordingly.
51.
May I please? Right, as per last order, my lord, respondent number 3 and 4 was duly served, my lord, but they had not appeared. this honorable court had granted 1 week time to appear, my lord. They have still not appeared. My lord, we fixed it up for admission as the service is completed.
It is submitted that service on respondent 3 and 4 have been completed by way of dusty service. But steps by registered post has also been taken,
My lord,
but the
dusty,
report is not back.
my lord, dusty service has been
No,
effectuated.
dusty is okay, but steps on by way of registered post has also been taken.
My lord.
So let the report come.
Ma'am.
It is also seen that by office note dated 1/5/2024, notices on respondents 3 and 4 are issued by registered posting. However, the report has not been received. So matter be listed after 3 weeks on a date to be fixed by the registry, enabling after 3 weeks and a report with regard to service of notice by the registered post. Be also entered. Be also reflected by the registry.
And there is an interim order.
Interim order passed earlier. Continue.
Deputy order.
Item 26.
Sincere apology, I was not able to be here when the matter was called, Lordship. But here our name has not been reflected, that's why I missed the matter.
All right, name not reflected, you go through the order and tell us whether it can be disposed of.
Yes, Lordship, it can be.
Can be disposed of.
Ma'am.
Okay.
Lordship, if I may. Lordship, beforehand, the Assam Pharmacy Council was defunct. There were no members. Right now, it is back on. The members have been elected. As a result of this, we can obtain our instructions. And Lordship may give us 10 days time. We'll obtain our
We are
instructions.
disposing it off in terms of the order passed by the division bench.
Oh, okay.
That there is an appellate forum.
Executive, yes, executive committee's decision need to be, my lord.
So they'll prefer an appeal.
My lord.
Is there a limitation
Yes,
for the appeal?
yes, 30 days
Huh.
from the date of confirmation. Now, they have, council has given the confirmation on 21 February 21st January 2022. And they have communicated to us on 29/4. So that appeal period, we could not avail that. So therefore, we have moved before this honorable court. And the similar relief has been given by the single bench also. Initially, it was, stay has been granted. And some documents has not been, could not be able to produce. So we have been given the liberty to file, bring on those documents. We have filed our affidavit. And since a similar petition has been disposed of with the.
What documents, are there any documents to be received?
My lord, we have filed the entire documents by filing the affidavit.
When did you receive these documents?
No, the executive committee resolution, we have not received, my lord. Kindly see, the impugn cancellation notice as 248. Page 248. This is,
48.
yes, this is the cancellation notice, my lord. With reference to the above, I am to inform you that your registration number has been cancelled permanently under section 36(1)(I) of the Pharmacies Act and remove your name from the register of Assam Pharmacy Council as you have failed to submit any relevant document justifying your qualification to substantiate your eligibility to register as pharmacist in terms of section 31(A) or 30(B), 31(C), 30(D) for the pharmacy in terms of order passed by the Honorable High Court. So. This has a reference of Executive Committee Resolution dated 17/8/2022 and confirmation by State Council under section 36(3) of the Pharmacy Act on 20th January 2023. Now, this too has not been provided. This has been communicated on 29/4/2023, my lord. They have taken the resolution on.
But your resolution has not been received.
My lord, that is why the division bench has directed that we may be allowed to approach the Assam Pharmacy Council, and then they will provide the exit committee resolution and the state confirmation. That is
And
landed
Lordship,
on
there were
21.
some directions also
And in
that
the-
after receipt of within 10 days, they will have to file an appeal.
The writ petition has been filed by the, how many petitioners?
15 minutes.
15 petitioners. Who claim to be registered under the Pharmacy Act. They are running what pharmacies?
My lord, they are
Running pharmacies. So, these petitioners were issued notices dated 29/4/2023. NHR 60 up to.
My lord, I will give the date. There are various dates on 29/4 on 31st. I'll provide the date.
On so and so date.
My lord.
By which their registration numbers have been cancelled permanently under section 36(1).
I.
Within bracket Roman 1. It is 36I or L?
36(1)I.
36(1)I. Of the Pharmacy Act 1948, and their names were removed from the registrar of the Assam Pharmacy Council. It was further informed that the Satan cancellation notice, the said cancellation notice has referred to the Executive Committee Resolution number 6, dated 17/8/2022, and confirmation by the State Council under section 36(3) of the Pharmacy Act of 1948. Learned councils at the bar submit that there is an alternative remedy. There is an alternative statutory remedy of filing an appeal.
My lord.
Before?
Under 36(4), before the state government.
Before the state government under section 36(4). Stop. The petitioners are required to avail the statutory alternative remedy before approaching this court. Stop. Learned counsel for the petitioner, however, submits that the appeal could not be preferred because the Executive Committee Resolution dated 17/8/2022 and confirmation by the State Council dated 2001/2023 has not been furnished.
My lord.
The writ petitioner. Stop. Learned counsel for the petitioner has also referred to the order dated so and so passed in writ appeal 431 of 2023, as well as order dated so and so passed in WPC 2623 of 2024 to submit that similar writ petitions have been disposed of, granting liberty to the petitioners therein to file an appeal, statutory appeal as mandated under section 34 of the Pharmacy Act 1948 upon the respondents has been disposed of with a direction to the respondents to furnish copies of the Executive Committee Resolution and confirmation by the State Council, and thereafter the petitioners therein were also granted liberty to file the statutory appeal.
My lord.
Within period of 30 days from the date of receipt of the Executive Committee Resolution as well as the confirmation by the State.
My lord.
Stop. Learned counsel for the petitioner submits that although several issues have been pressed into the writ petition, however, at this stage, you would like to pray for a similar order as have been passed by this court in writ appeal number 431 2023 and WPC number 6. Stop. The prayer of the writ petitioner is not opposed by the counsel to the respondent. Under such circumstances, writ petition stands disposed of with the following directions. Number 1, the respondents will furnish copies of the Executive Committee Resolution dated 17/08/2022, whereby the registration of the writ petitioner stood permanently cancelled. Yes. Stop. The respondents will also provide the confirmation of the executive committee resolution by the State Council as is required under Section 36(3) of the Pharmacy Act of 1948, and which was issued by the State Council on 2001/2023. Number 3, upon the documents referred to at serial number 1 and 2 above having been furnished to the writ petitioner, the petitioners are at liberty to prepare the statutory appeal under Section 34.
36(4).
36(4). Under Pharmacy Act so and so, within a period of 30 days from the date of receipt of the executive committee resolution and the confirmation by the State Council. So the respondents will ensure that the executive committee resolution dated 17/8/2022 and the confirmation by the State Council dated 2001/2023 be furnished to the writ petitioners within a period of 2 weeks from today.
From the date of receipt of certified copy.
From the date of receipt of certified copy of the
Till then, the imprint order may be stayed till they have for this. Because all the division bench orders and the single bench also, my lord, same release has been. I'm praying for that, my lord.
Till what?
Till the executive committee resolution has been provided to us.
Till the executive committee resolution as well as the confirmation by the state respondent, state council as directed above are provided or provided to by the petitioners. The cancellation of the licenses of the writ petitioners shall remain suspended.
My lord, obliged.